Amendment 223 to Clause 39 in the name of Kim Leadbeater, with which it will be convenient to consider Clause 39 stand apart. Kim Leadbeater to move Amendment 223, please.
Thank you, Chair. Again, this is a standard power for regulations to include the power to make incidental, consequential, transitional or saving provisions. These are minor amendments and changes, and this is a standard but vital measure that ensures the legislation works effectively and cohesively.
I beg your pardon. Sarah Aldi.
Thank you, Chair. This clause, as amended by Amendment 545, which we will vote on shortly, brings into stark contrast quite how much of the bill is to be left to regulations and how little say MPs will eventually get over it. When it comes to voting at third reading, MPs will have little certainty on how the bill will actually operate. So much is to be taken on trust, and if through these gaps and grey requirements people come to harm, that will be on Parliament for failing to address these issues while we have the chance. So let's consider all the powers which the bill creates. Clause 5. A power to determine what goes into the first declaration subject to the requirements of Amendment 418. Clause 5, 8, 19. Powers to determine the training, qualifications and experience of the medical practitioners with no minimum floor, and we don't even know who will ultimately decide the training. That too is to be left to regulations under Amendment 186. Clause 6. Forms of proof of identity, but no requirement for those to be photographic or to prove residency. Clause 7, 13, 21. The statements, declarations and reports required from the doctors and the applicant. Clause 11. Regulations for the replacement of the coordinating doctor if they've died, are ill or otherwise unable or unwilling. Clause 15. A new power to determine who can be a proxy. Clause 20. The approval of drugs and substances to end people's lives. Clause 28. The prescribing, dispensing, transporting of approved lethal substances, although the member for North West Hampshire has called this purely administrative. Clause 29, regulations relating to the registration, certification and recording of deaths. Clause 30, codes of practice which practitioners must simply have regard to. Clause 32, as it will be, extraordinarily broad Henry VIII power, as we're completely in the dark as to how this will actually be provided. Clause 33, what events should be notified to the Commissioner, how to enable the exchange of information, that's all to be decided by the Secretary of State, with the detail removed from the bill. All those are to be by the negative procedure, except the training and qualification requirement for the first and second doctor, the codes of conduct and the power on the Secretary of State to arrange for delivery of the state of assisted dying. There is no need to have a vote when a statutory instrument is made through the negative procedure. The only exception by convention is when the Leader of the Opposition asks for one, but the Leader of the Opposition would understandably not do so on a conscience issue. So, in practice, Parliament will never get a say on these matters. Is the committee content with that? But even for the affirmative statutory instruments, the say that Parliament gets is limited to a 90-minute debate on a motion that cannot be amended. So suppose that the Secretary of State published a code of practice on the assessment of capacity, which MPs felt did not take sufficient account of mental health conditions. They would be faced with either the option to vote for it, despite its inadequacy, or vote against it and risk creating a position where there are no codes of practice at all. It's an impossible position to place parliamentarians in, yet this is what the bill creates. It is a massive blank cheque to the executive. And I say to members opposite who I know have great faith in the Health Secretary that according to the Interpretation Act, Secretary of State means any Secretary of State. Those powers will not necessarily be exercised by the Health Secretary. They could be exercised by another Secretary of State. Indeed, under the doctrine of ministerial delegation, they could be delegated to another minister who is not a Secretary of State. I make these points to illustrate there is an issue of principle which cannot be waved away on the basis we think someone sensible will exercise those powers. Parliamentary scrutiny matters, and this bill avoids it through the use of these wide powers, and that is something that I very much regret. Thank you, Chair.
For the benefit of the record, I should have indicated that we are debating Amendment 223 to Clause 39, and the question is that that amendment be made. Minister?
Chair, Amendment 223, we've worked with the sponsor, the government has worked with the sponsor on this. This amendment broadens the regulation-making power using standard legal wording. This would mean that any regulations made under the bill could ensure that the legislation works effectively with other legislation. Thank you, sir.
I've got nothing further to add, Chair.
Amendment proposed, 223 to clause 39. The question is that amendment been made. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. We now come to Amendment 545 to clause 39, which has already been debated with Amendment 525. Kim Leadbeater to move formally.
Move forward, Chair.
Question is that Amendment 545 to clause 30, as on the order paper, be made. As many of that opinion say aye?
Aye.
Contrary, no?
No.
Division.
Division in room 10.
Lock the doors.
Yes, please.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell.
No.
Lambos Lambos.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green.
Aye.
Rachel Hopkins.
Aye.
Sir John Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Sorry.
Kim Leadbeater.
Aye.
Kit Bolthouse.
Aye.
Sarah Olney.
No.
Dr Simon Ofer.
Aye.
Rebecca Paul.
No.
Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Seville Roberts. Naz Shah.
No.
Dr Neil Shastrihurst.
Aye.
Dr Marie Tidball.
Aye.
Sean Woodcock.
No.
Thank you. The ayes were 15 and the noes were 8. So the ayes have it. Unlock. Miss Saville Roberts. Not moved? Amendments by leave not moved. Now come to the question that clause 39 stand apart. No? No takers. The question is, the clause 39 stand part of the bill. As many of that opinion say aye? Aye. Contrary, no? The ayes have it. Amendments 225 to clause 40, which has already been debated with 187. Kim Leadbeater to move formally.
Move forward, Chair.
The question is that Amendment 225 to clause 40, as on the order paper, be made. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. Again, Ms Saville Roberts, clause 40, not moved. Amendment withdrawn. Amendment 390 to clause 40, which has already been debated with clause 12 stand part. Kim Leadbeater to move formally.
Move forward, Chair.
Amendment 390 to clause 40, as on the order paper. The question is that amendment be made. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. Amendment 391 to clause 40, which has already been debated with clause 12 stand part. Kim Leadbeater to move formally.
Move forward, Chair.
Amendment 391 to clause 40, as on the order paper. The question is that amendment be made. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. We now come to Amendment 518 to clause 40 in the name of Dr Marie Tidball, with which it will be convenient to consider Amendment B to Amendment 518, Amendment A to Amendment 518, Amendments 519 and 520, Amendment B to Amendment 520, and Amendment A to Amendment 520. Dr Marie Tidball to move Amendment 518.
Thank you, Sir Roger. It is a pleasure to serve under your chairship. I rise to speak to Amendment 518, 519 and 520, which provide definitions of coercion, pressure and dishonesty, respectively, for the purposes of this bill. In my speech at second reading, I said I would want to ensure that the final stages of the bill define dishonesty, coercion and pressure. I have sketched out these definitions based on oral evidence during our witness sessions on the bill and have been grateful for the extremely helpful input from Laura Hoyano and Max Hill after those oral witness sessions in establishing the content and parameters of these definitions. We have spent a considerable amount of time in this committee discussing the safeguards against coercion, for example, but it felt to me we had not spent much time discussing the content and parameters of these concepts. Whilst I will not be pushing for a vote on these amendments today, for reasons I will outline, I do think it is important to ensure that our discussions of the concepts are on the public record. I will not be pushing these amendments to the vote, as I am convinced, further to discussions with legal colleagues and considering these issues very carefully, that the risk of setting the parameters on the face of the bill are too great in ossifying the courts in ensuring they use the full parameters of these concepts to encompass scenarios of the offences under Clause 26 of this bill in circumstances which may not currently be conceived of by this committee. In other words, I'm convinced that limiting the definitions of these concepts in the statute creates risks of excluding criminal behaviour where the threshold of the offence would otherwise be met in common law by the courts. Instead, mirroring the approach to coercion taken in the Serious Crime Act 2015, a point I will return to later, I believe that the Ministry of Justice must draw up details of these concepts and examples of their application in the context of the offences set out in Clause 26 of this bill. Doing so will be helpful for those medical practitioners using the bill, along with other professionals, if it is to become law, and in the training to be provided for them under the bill to enable medical practitioners to evaluate whether each patient has been subjected to coercion, pressure or dishonesty by another person to apply for assisted dying. In the criminal law, definitions of coercion, dishonesty and pressure are not placed on a statutory footing. Turning first to dishonesty, the lead case of Ivy and Genting Casinos is the lead case because there is no statutory definition for dishonesty. Instead, this case does not provide a definition, it provides a two-stage test. The courts are familiar with the legal elements of dishonesty from case law, where it had for a long time a part subjective and part objective test applied for many years in Gosh, and as now amended in 2020 by the Supreme Court in Ivy, which disapproved the former test but retained the question, was his or her conduct dishonest by the standards of an ordinary decent person? Similarly, pressure does not have a statutory definition within the criminal law, but means essentially forcing someone to do something against their will. I am satisfied, having looked at this issue very carefully, that the wording in Clause 26 is enough to signal what anyone involved in a relevant application to bring a criminal prosecution for what should be looked for in terms of act and intent. Thus, the common law is well placed to further develop these concepts in the context of the offences relating, as set out in Clause 26. I want to spend some more time looking at coercion, as safeguarding against this has been at the forefront of our minds throughout the oral evidence process and the course of this bill committee. Section 76 of the Serious Crime Act 2015 is the only statute which currently uses this concept, but it does not provide a statutory definition of it. Instead, the 2023 Home Office guidance defined it as controlling and coercive behaviour, but non-exhaustively as acts designed to make a person feel inferior and or dependent by keeping them apart from friends, help and support. It can include taking advantage of their money and things they have, stopping their independence and controlling what they want to do. As important as this legislation and associated guidance is in identifying coercion in the context of domestic abuse, it did not seem to me to be sufficient in understanding coercion for the purposes of this bill. In particular, it does not create a sufficient nexus to the inducement to make a first or second declaration nor to cancel such a declaration in Clause 26 subsection 1, nor does it reflect the inducement in Clause 26 subsection 2 to self-administer an approved substance by dishonesty, coercion or pressure. This is why my definition creates a direct link to the two dimensions of these offences. In the definition in my amendment on coercion, coercion means behaviour of a controlling or threatening character, including but not limited to emotional or financial control or improper interference with another person's decision-making autonomy, which is exerted by a person or organisation with the intention of inducing that other person to make the relevant declarations or to administer an approved substance under this bill against that other person's will. My definition would therefore encompass individual incidents as well as cumulative and repeated acts of behaviour of controlling or threatening character. In addition to reflecting the elements of emotional and financial control or threatening behaviour in the Home Office guidance for the Serious Crime Act 2015, my proposed definition includes improper interference with another person's decision-making autonomy. This aspect is to ensure that it reflects where an individual volition has in fact been usurped by another person or organisation. Forgive me one moment, if you may. Sorry, forgive me one moment. I'm nearly there. I realise I picked up the wrong version. But we're fine, we're good to go. It's getting late. My definition ensures that, as I've just said, it reflects a scenario where an individual's volition has been usurped by another person or organisation. Vitiating consent to a first and second application, or not to cancel such a declaration, or to self-administer an approved substance under the bill need not fit the full definition of coercive and controlling relationships as defined under the Serious Crime Act 2015. Thus, further relevant guidance issued under codes of practice must also reflect this point, an issue I will return to shortly. I include organisation because it was important to me to demonstrate our intention that organisations can be vicariously liable for actions of their employees and officers who, in the course of their employment, induce another person by dishonesty, coercion or pressure. I will return later in my speech as to why fettering the definition on the face of the bill creates greater risk than it safeguards against. But at this point, I wanted to acknowledge the amendment made by my honourable friend and the member for Lowestoft in Amendment 518B and 520B. She proposes including where the person is in an intimate or family relationship with that other person. My intention in using the term person is deliberately broad in order to ensure we maximise the scenarios which we would want to be captured by the offences in Clause 26. I support the Honourable Member for Lowestoft's principle, but believe narrowing this in this way on the face of the bill would be unhelpful. However, I absolutely agree that guidance and training on this concept should encompass such individuals. Indeed, I am satisfied that the clear and succinct language in Clause 26, a person who by dishonesty, coercion or pressure induces another person, follows a standard legal formulation in the broadest possible sense to encompass the groups that she describes. The ability of members of the medical profession to identify such persons was helpfully expounded in the oral evidence sessions heard by this committee. I asked Professor Nicola Ranger from the Royal College of Nursing how her members would detect coercion, undue pressure or dishonesty by family members or other people supporting parties on which the patient was relying in relation to seeking assistance. Her response was very strong. Professor Ranger said, "Safeguarding is part of our professional responsibility now. Whether it is for a child, an adult or an elderly person, part of our role is to be vigilant against financial misconduct, physical abuse and mental health abuse. Any of those things is a responsibility of every nurse now. It is a very good and simple process. You do not have to investigate or give a judgment. You need to refer it to be investigated. That takes the pressure off an individual clinician. Our job is to be vigilant and to refer safeguarding anywhere we think that there is any form of abuse. I think that that process would remain and could be part of how we do things now," she ended. Turning to the next element of my formulation, intention of inducing. This is a key foundation of our understanding of coercion under the bill and reflects the criminal prosecution which must follow the inducement set out in Clause 26. As I have said, I brought these amendments as probing amendments. However, I reject the Honourable Member for East Wiltshire's amendment 518A and 520A because every criminal offence must have two elements, the prohibited act, or the actus reus, and the state of mind, the mens rea, accompanying it as specified. The member for East Wiltshire's amendment would sever that link with these foundational elements of a criminal offence by removing the necessary mens rea element from the intention to inducing in my definition. Without the intention being specified then, coercion, pressure or dishonesty become offences without any context whatsoever. I will continue and make progress. Training about coercion, dishonesty and pressure must ensure that, as well as enabling medical practitioners to identify both the prohibited acts as well as the state of mind required to amount to an offence under clause 26 of the bill. I am extraordinarily grateful to Max Hill KC, Alex Ruck-Keane and Laura Hayano in their helpful input following our oral evidence proceedings in reviewing my proposed amendments and their perspectives on the benefits and disbenefits of placing definitions on the face of the bill. Alex Ruck-Keane succinctly set out the risks. If you start trying to get precise, you run the risk of arguments that the definition is exhaustive. He does emphasise, however, the need for statutory guidance to address these issues. As a consequence, and having made careful deliberation on these issues, I think the best solution is to mirror the approach to coercion in the Serious Crime Act 2015. The Act itself does not set out a definition in Section 76 on coercion. Instead, the statutory guidance issued by the Home Office in 2023 details these concepts and examples of their application. In the context of the bill before us today, and the offences set out in clause 26 of this bill, guidance on dishonesty, coercion and pressure could be drawn up under either clause 30 Codes of Practice by the Secretary of State or clause 31 in guidance from the Chief Medical Officer. Further detail could also be provided in the regulations under training in respect of domestic abuse, including coercive control as set out in Amendment 22. Such additional explanatory notes on the concepts of dishonesty, coercion and pressure under the Codes of Practice or guidance from the Chief Medical Officer would also facilitate the Commissioner in ensuring that each member of the panel has training in relation to domestic abuse, including coercive control and financial abuse under Amendment C to NS2, which I hope we will support. Elaborating on these concepts under either clause 30 or 31 will be helpful for those medical practitioners using the bill, if it is to become law, and in the training to be provided for them under this bill. It will enable those medical practitioners and other relevant professionals to evaluate whether each patient has been subject to coercion, pressure or dishonesty by another person in seeking assistance. In conclusion, I will not be putting my amendments to a vote because the risks outweigh the benefits. As explained, explanatory notes in either Codes of Practice issued under Clause 30 or guidance under Clause 31 from the Chief Medical Officer would work best in order to avoid bespoke definitions within this bill being misapplied across criminal law more generally. I have taken on board the evidence we heard in oral witness evidence and made sure that I have considered carefully the anxiety that some of those witnesses indicated, that we must not stymie the statute with definitions which are too tightly drawn, thus missing important legal nuances in the scenarios this bill would want us to contemplate and would require further careful guidance upon. Therefore, I would urge the Secretary of State and Chief Medical Officers, along with the Ministers and policymakers implementing this bill, to perceive a very clear intent when producing the Codes of Practice and the guidance by the Chief Medical Officer to spell out in more detail the application of these concepts of dishonesty, coercion and pressure in the very specific context of this bill.
Amendment 518 to Clause 40 as on the amendment paper has been proposed. The question is, that amendment been made? One moment. Let's get slightly more complex. In the legislative alphabet, B comes before A. I'm sure everybody understands that. Of course it does. So, Does anybody wish to move Amendment B to Amendment 518? If not, I shall move to Amendment A. No, Sean? You wish to move it?
518B and 520B.
I'm talking, yeah, B.
Yes.
Right. So, the question is that Amendment B to Amendment 518 be made. Nazshah.
Thank you, Chair. I stand to move Amendment B to Amendment 518 and also Amendment B to Amendment 520. Whilst I appreciate the member for Stockbridge Penston is not moving her amendments to a vote, I think it is important to get a few things on the record. I'm moving these because they were tabled by my honourable friend for Lowestoft. Before I speak further, my honourable friend, the bill's sponsor, has accepted several amendments tabled by the honourable member for Lowestoft before. And I don't know what her response is, given that the member for Stockbridge isn't moving her amendment, and whether she, well, this throws, it's thrown me off track, to be fair, because I wasn't expecting it not to be moved. Either way, let's move on. It was really interesting. I thank the honourable member for her detailed presentation to the committee. I'm not sure I agree with it entirely, though. Whilst there might be a point, I think, from a legal perspective, that these offences do actually exist in law, the truth remains, the facts remain, when it comes to domestic violence, and we're talking about coercion and these things that we've debated extensively during this committee. We have put the training in, we've done all of those things, but to not put it on the face of a bill, it contradicts slightly where I'm sitting from, is the conversation we had last week. Because last week, the honourable member who sponsored, my honourable friend who sponsored the bill, has put on the face of the bill, specified the sentence for somebody who should be found guilty of coercion or coercing somebody. So, for example, if somebody was found to be guilty of coercing somebody who then died, that would carry that life sentence.
Will she give way?
So if I just may make my point, and I'm happy to give way because I want to understand it much better. So my understanding is there would have been no need for that amendment because we already have those laws in existence for murder, and that would be murder. But happy to give way.
Dr. Marie Tindall.
Thank you. So clause 26 puts in place the offences, the elements of the offences under this bill, but which is right that it should, and draw those parameters very tightly and firmly. But under the criminal law, it is these concepts nowhere else are defined on the face of the statute. And my severe concern, having listened to this committee and its worries about concepts like coercion, that we risk restricting our understanding of the concepts too tightly and therefore excluding the kind of cases that we would want to include by leaving them clearly but not defined on the face of the bill. What we enable the common law courts to do is interpret the facts on the basis of real people's lives that come before them. And I want to make sure that where it's right and proper that those courts interpret the law on the basis of those facts, they are able to do that and not restricted by an overly limited definition that we might place on the face of the bill. So it's because I want to ensure that there are more cases that can be encompassed rather than less. However, as I said in my speech, and forgive me, Chair, but I think it's an important point, as I said in my speech, we've talked about these concepts in quite an abstract sense, and I wanted us today to ground that in the reality of what we might want guidance and further advice on those concepts to look like in practice. That would follow convention, as I've said already, in other areas of the law, like in domestic abuse, where the primary legislation doesn't define the concept, but the secondary legislation provides further details and real-life examples for practitioners and the courts.
I thank the honourable member for her intervention and her detailed explanation. And she does absolutely make sense. I wouldn't want to restrict that either. But it does leave with me, and perhaps she is entirely correct. No doubt she's researched it really well. But we have in some instances, we have, from looking at clause 26, which she has raised, it does mention coercion, and it does mention pressure, and it does say all of that on the face of the bill. And if she wants to leave it in that context, I don't think if we have put here dishonesty, coercion and pressure induces another person to self-administer an approved substance. And again, we've repeated that in two of those lines, section 26, clause 26.1 and clause 26.2 as well. Then I would still be minded to make at least something further on the face of this bill as it is. I'm not sure it would restrict us, it would just give us a helpful even. And I don't know whether the Minister can respond by saying whether the idea is, if she doesn't put it to a vote, whether the Minister would accept that there would be statutory guidance on this. I don't know whether the Ministers can respond now or whether they want to wait till in their summing up. I'm happy to give way. Okay? They're not going to, right, that's fine. Okay, so I would like to, I will talk through the Member for Lowestoft's amendments and why she felt it was important, and certainly why I felt it was important, just to put this on the record. Amendment 518 gave the bill a definition of coercion, and 520 does the same for pressure. This gives welcome clarity to the bill on two important issues. And what my honourable friend for Lowestoft's amendment would have added the language after the original amendments talk about a person or organisation who was engaging in either pressure in 5118 or coercion in 520. After the words person or organisation, the amendments would have read, including where the person is an intimate or family in an intimate family relationship with that other person. So that was just extending it to make sure that we covered that bit in particular.
Will she give way?
Happy to give way.
I really thank her for this, for her speech, and I think we are united on principle, but perhaps take different views on the best way to ensure that this happens in practice. Using the word, just to give an example, intimate in those circumstances, that might, where a court to interpret it, include a husband or a wife or a partner, but may not include a brother or a sister or a parent. And so already, in using that one word, we have potentially created further risks that a court, with us defining it in the circumstances set out by the Honourable Member for Lowestoft, we are excluding a relationship that we would want the court to look at and to weigh and judge whether there was potential dishonesty, coercion and pressure by that person in that relationship with the person seeking assistance. So I give that as just one example of the risk created by adding language in, rather than leaving it more broadly for a court to interpret on the basis of the facts of the case.
I thank my honourable friend for her intervention, and if I just reread that, it's including where the person is in an intimate or family relationship. So the family relationship with that other person, I think, was meaning extended for siblings, or that was my interpretation, but perhaps that's what I would have interpreted it as. So, and I think the other thing for me is that when we, last week we spoke extensively, I think it was last week or maybe even the week before, when we were talking about suicide and women in particular, the number of women that have that die commit suicide in particular following domestic violence has increased. Indeed, it was on the front page of The Guardian today. And how that is defined by our lawmakers is that intimate partner violence and it could be other violence. Yeah, if I could just finish my point. So in that case, we are, as a government, as lawmakers, we do define those women that are killed by members of a family or intimate partners. Those are the numbers that our Minister for Violence Against Women does read out that list. So I'm happy to give way.
Thank you. Alex Keen's sage words to me were that the problem with putting more words in is you create an opportunity for lawyers to find loopholes. And in the example that she has just said to me, where we are talking about family relationships, I think we would all agree, having considered this evidence very thoroughly through the course of this committee, we would not want any interpretation of the offences as set out in section 26 to exclude, for example, carer relationships, where it wouldn't be a family member, but a carer might give close personal care to someone with a terminal illness, and we wouldn't want the courts to think that it was the parliamentary intention of this committee to delimit it to intimate relationships or family relationships only. And there is a risk that the more and more we narrow it by example, rather than leaving the term broad as it is currently, person, we risk delimiting it too far in a way that we would not want to exclude a situation where we hope that an offence and a prosecution would be brought by the court.
I thank the honourable member, my honourable friend, for her explanation, and it's a very, very good one. And you're absolutely right. I absolutely agree with her. That it could possibly, and I'd be honest with you, I haven't got enough time to go away and think about it more from a legal perspective, because I've only just heard her arguments. But at the moment, I can absolutely agree with her. But in terms of the member for Lowestoft, I think I do want to thank her for her attempt, because of her experience, of years of experience of working in this field, and she tabled that amendment in response to my honourable friend's amendment, with the best of intentions to strengthening the legislation. But I will go back and look at it. I may even come back during the debate. Thank you.
Amendment 518 to clause 40, as on the order paper, has been moved, since when an amendment has also been moved. That is Amendment B to Amendment 518. The question is that Amendment B to 518 be made, and for the avoidance of doubt, can I indicate that we are also considering Amendment A to 518, Amendments 519 and 520, Amendment B to 520, and Amendment A to Amendment 520. So we're now going to broaden the debate, having dealt with the First Amendment, to include everything else on the order paper. Danny Kruger.
Very helpful, Sir Roger. Thank you. So I'm very grateful. That was a very interesting exchange, and I think I agree with the member for Penistone and Stocksbridge more than I do with the member for Bradford West. It's an uncomfortable situation for me. But just to show that I am actually listening, I wanted to state that. And I also agree with the Minister, because I think because she said last week, the Justice Minister, that the terms of coercion and pressure without statutory meaning have their natural ordinary meaning, well understood by the public and the courts alike. And while throughout the course of the committee's deliberations, I have encouraged more clarification, more clarity, I do accept the point made by the Honourable Lady and by the Minister that we are in a good place in outline in terms of understanding these concepts. But I agree with both honourable members that it would be helpful for further clarity from the ministers, and if there is guidance to come, I think it's important that we proceed with due respect to the points that have been made, including, by the way, the proposals from the member for Lowestoft, which I agree with in principle as well. However, if guidance is to come, I do want to make the point behind my amendment A to the member for Penistone and Stocksbridge amendments, even though I understand she's not going to push her amendments, therefore mine won't come either. And in response to her challenge to me about the purpose of these amendments, I want to try and explain that. So there are two places in the bill where the concepts of coercion and pressure occur. One is in the context of the assessment process, the eligibility for assisted death, and the other is in terms of the criminal offence of coercion into an assisted death. And these are two separate areas of the bill, but they have the same terminology, and in fact the same principle is behind them both, which is of course coercion. The point of my amendments was to make clear the distinction between eligibility and the criminality involved in coercion. And whereas I entirely agree with the Honourable Lady in her argument that it would be appropriate to retain the principle of intention, because probably just to be clear to members, my amendment will remove the second half of her amendment, removing the requirement for there to be evidence of intention to coerce. leaving just the fact of coercion in the definition. The Honourable Lady's point was that it's important to retain evidence of intention in order for the criminal offence to be meaningful, and I accept that that is a point in criminal law. But where the term and the concept of coercion applies in the context of the assessment of the eligibility criteria, I think it's very important that we don't include intention, for the simple reason that it may well be that somebody is coerced into an assisted death in a way that we would all understand, whereas the perpetrator may not have had the actual explicit intention of that outcome. So an example would be where an abusive husband, through abuse, through victimization, through relentless unkindness, and the direct communication perhaps to his victim, to his wife, you'd be better off dead, has the effect that we would all understand, and it might indeed be subject to criminal prosecution on these terms, that he had coerced her into seeking an assisted death in response to this pattern of abuse. He would nevertheless be able potentially to claim that was not his intention, and indeed perhaps it wasn't. He might not have had the explicit thought in his head, I want to make her apply for an assisted death. Nevertheless, that is the consequence of his coercive behaviour. So, and I would hope that when the doctors are assessing that particular case, and they did come across evidence of that sort of practice, that sort of pattern of abuse, they would conclude this person is being coerced, and therefore they would not proceed, they would not award the applicant the green light to proceed. So that's an example of where I think it is important to remove the intention of coercion from the definition. Whereas I entirely agree with her, and I recognise the value and the necessity, indeed, of having an intent if we are talking about the criminal offence of inducing somebody to have an assisted death. So, just lastly on this, if you think about it from the point of view of the doctor or the panel who are approving or being asked to approve the application, if it is required that if the definition of coercion includes the intention to coerce, we are then inviting, in fact requiring, the doctor or the panel to seek evidence of the intention of the person doing the coercion, rather than just the fact of the patient having been coerced. And that is we would require them to somehow interview the abuser. I mean, I think we get into difficult territory if we do insist on evidence of coercion in order to conclude that there has been coercion, and on that basis to deny the application. So I hope that helps to explain the purpose behind my amendment. I know slightly academic, because we're not proceeding with the amendment as a whole, but if it is the case that the Minister or the sponsor has the intention of reflecting some of the points made by the Honourable Lady in subsequent amendments or in guidance, I hope those points will be taken on board. Thank you.
Rebecca Paul.
Thank you, Sir Roger. It's a pleasure to serve under your chairmanship this evening. I rise to speak on Amendment 518 and 520. So it's, as we've been saying, it's obviously really important that we understand what coercion means in a legal sense. And I'm really grateful to the Honourable Member for trying to do that, because it's not an easy task by any measure. But like her, I am concerned that defining it in this way may actually make it harder to prove coercion and may actually undermine the safeguards of the bill. So under the amendment, the assessing doctors and the panel are meant to look not just for evidence of coercion, but evidence of intent to induce assisted suicide, and they will have to show that the applicant is requesting assisted suicide against their will. This could make the law powerless against many kinds of behaviour that we would want to prohibit. So to start with the point about intent, coercion and pressure take many forms, and they do not always involve a clear intent. So take family relationships, for example, which amendments 518B and 520B from the Honourable Member for Lowestoft very reasonably draw attention to. In the debate at second reading, the Honourable Member for Hackney North and Stoke Newington said, and I quote, people do not generally write letters to sick relatives urging them to consider assisted suicide and then put those letters on file. Coercion in the family context can be about not what you say, but what you do not say, the long, meaningful pause. But even in more blatant cases, we cannot necessarily prove an intent directed towards assisted suicide. So Sue Smith, a clinical psychologist, said in written evidence that coercive control often ramps up when the abused partner receives a cancer diagnosis. So she says, and I quote, "The seriousness of the cancer diagnosis may be systematically and actively denied or minimised. Claims can be made by the male partner that she is attention-seeking, or she is accused of making up the effects of treatment and could be left isolated and alone when in physical need. A woman learns to doubt her reality and experience and is extremely isolated. This can lead to heightened anxiety, hopelessness and helplessness, and abject despair, which can lead a person to wishing they were dead." That could be seen as coercion towards assisted suicide. But in this scenario, does the abusive partner demonstrate a clear intent towards that? I'm not sure that it could be demonstrated by the doctor or the panel in that instance, especially as they only need to be satisfied on the balance of probabilities that there is no coercion. So if the panel think there is a 45% chance there is intent, but no more than that, they have to grant the application, I would say. The harrowing story of Ryan Wellings and Kienna Dawes shows that even when coercion can be proved, proving that an abuser intends someone else's suicide is a completely different matter. After Kienna Dawes took her own life, Wellings was convicted of coercive control and of assault. The judge told him, "From May 2020 until her death, you abused, assaulted, exploited, controlled and demeaned her. When she died, it is clear that she had begun to believe your lies to the effect that she was deranged, physically disgusting, friendless, worthless and an unfit mother. You had persuaded her that she had no one to turn to." Before her death, Dawes wrote a note saying, "Ryan Wellings killed me." Although he was convicted on other counts, Wellings was acquitted of manslaughter. So that demonstrates that coercive control, even if it is followed by suicide, doesn't always mean that intent can be demonstrated. It's really tricky. Similarly, people may pressurise a relative without intending to override their will. The barrister Ruth Hughes KC, who has been quoted before in these sittings, says in her comments on the bill, and I quote, "It is surprisingly easy for a relative, whilst completing a variation on the classic asset strip, to persuade themselves that they are actually acting in their Aunt Dorothy's best interest or in accordance with her wishes." In other words, someone can pressurise a relative into assisted suicide without exactly intending to. Again, including intent here could actually muddy the waters. I have a similar concern about the phrase "against that other person's will." That sounds very straightforward, but again, in practice, it can be much less clear. So part of the effect of coercion is that people lose confidence in their own will and adopt that of others. In written evidence, many frontline workers have pointed out that coercion does not always clearly appear as someone acting against their will. Janet Rees, a specialist doctor in palliative care in Wolverhampton, says patients will not, and I quote, "even necessarily be aware of being coerced." And Dr. Jennifer Hard-Dvorak, a senior lecturer at Christchurch, Canterbury University, specialising in medical law, says the bill does not consider how, and I quote, "people internalise feelings of coercion and act on this." If someone has internalised a feeling that they would be better off dead, that may be their will, even if we hope we could change it. Annie Donaldson, a domestic abuse expert at the University of Strathclyde, said, and I quote, "Decades of work examining the impact of coercive and controlling behaviour has shown that coercive control is not merely persuasion, but a complete change in the perspective of the victim, so that she truly believes that she is worthless, a burden to her partner or wider family, and would not be missed should she die." Women are regularly humiliated, demeaned and told they would be better off dead, or that they are a useless mother, I'm still quoting by the way, or that the children would be better off without them. This abuse erodes women's confidence, autonomy and self-esteem. Cut off from support, women often come to believe these lies, fearing reprisals from their partner if they report the abuse. Many choose to tell no one. This long-term relentless dehumanising process can result in a woman believing that she is disposable. Similarly, the writer and campaigner Sarah Ditton warns that the bill may not protect. And she says, the patient who, through lengthy cruelty and coercion from a partner or carer, becomes genuinely convinced that she, or sometimes he, is a burden who would be better off dead. Such a person may even refuse treatment, causing a curable disease to become terminal and placing them within the purview of the bill. So we might not believe that assisted suicide is in someone's best interest, but there is no best interest test in the bill or in this amendment, just a reference to the person's will. If a victim of coercive control truly believes that they ought to die, it is not clear how the doctor or the panel can refuse their application unless coercion can actually be proved, and proving it is not always easy, as we've just spoken about. My own friend, the member for East Wiltshire, has tabled amendments to remove the phrase against the other person's will. Obviously, it is all academic now, as we're not moving this to a vote, but I would support those because the phrase does more to narrow the definition than anything else, I would suggest. On another point, both Amendments 518 and 520 refer to pressure and coercion from organisations. I don't know exactly what the Honourable Member has in mind with this specifically. I guess one example might be the cases we've heard about in other jurisdictions where a health insurer or provider tells someone that they can't fund a treatment but can fund assisted dying options. It could well be that the Honourable Lady had other things in mind there. That would possibly count as pressure under some circumstances, but it would be very hard to show that there was intent on the part of the organisation. So it's not clear that this amendment helps us to identify and avoid coercion and pressure in that sense. Before I finish, I would just like to point out something else which may be missing from these amendments, and it's my favourite one. It's the question of undue influence. I'm so sorry, Minister. Which I know we have gone over a few times.
Will she give way?
I will, of course, give way.
I mean, just to, thank you, slightly put this one to bed, which is I think where we all need to go at this stage. I did seek advice from those that have worked in this field, and it is not a concept used commonly in the criminal law. It is instead used in the law of equity and would not be as relevant in this context. And so there were other sharper elements that could make up this concept of coercion that were better and more well understood in the context of the criminal law.
Rebecca Paul.
I thank the Honourable Lady for that contribution and clarifying the evidence and the information she has been given on that front. So the question of undue influence, I promise I won't talk about it for very long, I promise, which I know we've gone over a few times, but it does seem really relevant. I do think it's important, that's why I do keep raising it. Lord Nichols, in a 2001 judgment, which my honourable friend, the member for Solihull West and Shirley, has previously mentioned, said undue influence includes two things. So first, overt acts of improper pressure or coercion, and second, a kind of influence which, and I quote, arises out of a relationship between two persons where one has acquired over another a measure of influence or ascendancy of which the ascendant person then takes unfair advantage. The influence one person has over another provides scope for misuse without any specific overt acts of persuasion. The relationship between two individuals may be such that without more, one of them is disposed to agree a course of action proposed by the other. So that definition to me suggests something broader than what is described in the amendments 518 and 520, but I take the point that the Honourable Lady has just clarified on. So the amendment suggests that somebody will actively interfere with someone else's decision-making autonomy and have an intention to induce them to do something. But Lord Nichols' definition of undue influence is much less dramatic. It just identifies a relationship where one person's view holds a lot of sway. So for the last time, I promise I would be grateful for the Minister's view on that, and I'm sure she's going to talk through that point and clarify what the Honourable Lady just provided in terms of advice on this. So in conclusion, although completely well intended, and I think it's a really helpful thing that the Honourable Lady tabled these amendments and we've had this debate. Really grateful to her for doing that. But I'm inclined to think that they're actually going to narrow it too much. So my preference would be that we remain with what we have, subject to the points I've already raised previously many times on undue influence and
Will she give way?
I will, of course, give way.
I'm grateful, and would she agree with me that it has been therefore helpful to have this on record, that we have evaluated these concepts from all sides and determined that putting them on the face of the bill is not the right thing to do and would be too restrictive at this point?
I thank the Honourable Lady. I think based on this definition, I wouldn't choose to have this specific definition on the face of the bill. That doesn't mean that if there may well be another definition that I would be more comfortable with, so I can't rule that out. But I can completely agree with the Honourable Lady that I think this has been a really, really helpful debate, and I really appreciate her taking the amendment so that we could have it. So thank you.
Minister.
There will be one moment, Chair. Just had a message through and I wanted to see if it was relevant to what I'm about to say. Forgive me. Excellent.
I think it says keep it brief.
Yeah. Checking that my eyes aren't failing me. Well, look, it's welcome to see consensus break out across the committee in relation to these clauses, and for what it's worth. I think both as a government minister and as a member of this committee, I think that it is really excellent that we've had this debate and canvass these issues around these definitions in which I think all members of the committee have an interest in seeing and ensuring that where these words, coercion, pressure and dishonesty, which run through all the relevant amendments, appear in the legislation and in the draft bill, whether in respect of the eligibility criteria or indeed in respect of the criminal offences, that they operate as intended and with the breadth to capture the range of behaviours which they are seeking to safeguard against. I am going to be brief because we have rehearsed a number of these issues before, and indeed the honourable member for Penistone and Stocksbridge has stolen my thunder in many respects and said a lot of what I was going to say. But in relation to the definitions of coercion, pressure and dishonesty to which the various amendments relate, it's important to note, and it's the government's view, that including a statutory definition risks overcomplicating the issue and inadvertently, as we've heard, narrowing the intended protections which the criminal offences in the context of this bill are intended to provide. At the moment, the bill does not include a statutory definition for any of these terms. As a consequence, those terms carry their natural meaning as construed by the courts, and as such, they have in practice, they have a broad meaning. And so, for example, in the case of F and M of 1921, Mr. Justice Hayden stated that the expression controlling and coercive behaviour in the context of the Serious Crime Act, Section 76, 2015, where that term coercion appears, it's not given any legal definition because it doesn't require one. And that's because the term, as applied by the courts, is unambiguous, usually involving a pattern of acts encompassing, for example, assault, intimidation, humiliation and threats, and indeed the wide range of ways in which coercion and pressure can manifest themselves have been captured by the common law. So, for example, isolating a person from friends and family and support networks, restricting access to a doctor, which might be pertinent in this context. These are the sorts of range of behaviours that are captured in the common law by these terms. And so by giving each of these words their normal meaning, the terms are capturing all the behaviour, all the types of behaviour you would expect it to do, from the subtle to the explicit, allowing the courts the flexibility to consider the broadest range of behaviours, which I understand is also the policy intent of the sponsoring member. And as you're all well aware, government's role is to ensure that the law, as decided by Parliament, is robust, is workable. Our position is, in common with others, that adding these definitions risks having the opposite effect from that intended. These are well understood terms within our corpus of law, and adding any statutory definitions risks putting that in doubt in a way which is both confusing for the professionals that need to apply it, in ways that might restrict the prosecutorial discretion and actually narrow the very safeguards which they're intended to provide. And to her specific point, I would reiterate that breadth of the range of meanings captured by coercion and pressure would, in the government's view, encompass what she, I think, is concerned about in terms of undue influence. It would be caught by those terms in practice. That's all I intend to say, Roger.
Thank you, Chair. I think it's fair to say we've had a very valuable discussion on the matters relating to these amendments, and I'd like to thank my honourable friend, the member for Penston and Stocksbridge, for the considerable amount of hard work she has put into researching these issues. As always, she has been extremely thorough and diligent in her approach. I've been on my own journey regarding the need or otherwise to place definitions on the face of the bill, but having undertaken the valuable discussions we've had through this committee, and I think this genuinely has been the committee at its best, along with the expert legal input and advice my honourable friend and the committee has had, I think we're in the right place to enable the courts to ensure the law is as expansive as possible, and we do not create a scenario where certain behaviours from those with malintent under the bill are excluded from its scope. As such, I agree that we should allow the courts to do their job with the broadest possible powers to prosecute offences under the bill. And I echo my honourable friend's comments to the Minister about the need for the inclusion of details about these issues in guidance and codes of practice. But I thank members of the committee for what has been an extremely useful and productive discussion.
Dr. Tindall.
Withdrawn.
Not yet in your gift.
I thought you were asking me, sorry.
No, I was asking you if you wish to wind up the debate, but it's not yet in your gift to withdraw.
Thank you, Sir Roger, and apologise for my eagerness. It's getting late in the day. I am grateful for the thorough and thoughtful discussion that we've had from both sides of this chamber, and I am pleased and reassured that we now have that discussion on record, so that those looking at the work that we've done in this committee will understand the depths and levels we have thought about these important concepts in this space, and the extent to which we have challenged and checked government ministers in making sure that they understand our concerns, that these are properly put in place. I also thank the Honourable Member for Lowestoft for her important input, and know and hope that those things will be reflected in training. I think all I will say is I am glad that we've come this far, and we have a level of unanimity across both sides of this chamber. I think that is a nice point to reach coming towards the end of this journey as a committee, and reflects the essence and certainly the intention that was so evident in Parliament at the second reading.
We now come to Amendment B. Shah, you indicate whether or not you wish to move it or withdraw. So, Amendment B withdrawn by leave of the committee. Mr. Kruger, is it your wish to withdraw Amendment A, or do you wish to move it? Now is your moment.
Withdraw.
So, I forgot what it is now. Amendment 518 to Clause 40 by leave of the committee withdrawn. I take it there are no objections. We now come to Amendment 392, Clause 40, in the name of Kim Leadbeater, with which it will be convenient to take Amendments 424 to 393. Kim Leadbeater to move Amendment 392, please.
Thank you, Chair. Chair, this group of amendments are drafting changes, but they're important drafting changes in that they are about the definitions around first assessment, first declaration, second assessment, second declaration and preliminary discussion. So whilst they are only small changes, they're important changes, and I hope the committee can seek to support them.
Amendment 392 to clause 40 as on the order paper proposed. The question is, the amendment been made? Minister?
Thank you, Sir Roger. We've been working with the member for Spen Valley, and some amendments have been mutually agreed upon by herself and the government with the aim of ensuring the workability of the bill. This includes all three amendments in this group, and I shall therefore provide a brief technical factual explanation and rationale for them. 392 adds the meaning of first assessment and first declaration to the list of definitions in the interpretation provision in clause 40 of the bill. The effect of this amendment is to ensure that all references to first assessment and first declaration are interpreted consistently throughout the bill. 393 inserts the meaning of second assessment and second declaration to the list of definitions in the interpretation provision in clause 40 of this bill. The effect of this amendment is to ensure that all references to second amendment and second declaration are interpreted consistently throughout the bill. Amendment 424, as set out in clause 4, subsection 3, where a person indicates to a registered medical practitioner that they wish to seek assistance to end their own life in accordance with this bill, the practitioner may conduct a preliminary discussion about the requirements which need to be met in order to be provided with assistance. Clause 4, subsection 4, as amended, sets out that where a practitioner conducts a preliminary discussion, they must explain and discuss certain matters with the person concerned. This includes the person's diagnosis and prognosis, any treatment available and the likely effect of it, and all appropriate palliative, hospice or other care, including symptom management and psychological support. The preliminary discussion may not be conducted in isolation from an explanation of and discussion about these matters. 424 adds a definition of preliminary discussion to the list of definitions in clause 40 to ensure that all references to a preliminary discussion in this bill are interpreted in line with the description of the discussion mentioned in clause 4, subsection 3. Thank you, Sir Roger.
Kim Levitt.
Got nothing further to add, Chair.
Amendment 392 to clause 40. The question is that amendment 392 to clause 40 be made. As many of that opinion say aye? Aye. Contrary, no? Ayes have it. Amendment 519 to clause 40, which has already been debated with 518. Dr. Tidball, do you wish to move the amendment? Oh, she's not there.
She's not here, but she did indicate she
Not there. Amendment 226 to clause 40, which has already been debated with Amendment 187. Kim Leadbeater to move formally.
Move formally, Chair.
Amendment 226 to clause 40 as on the order paper. As many of that opinion say aye?
Aye.
Contrary, no? Ayes have it. Amendment 424 to clause 40, which has already been debated with 392. Kim Leadbeater to move formally.
Move formally, Chair.
Amendment 424 to clause 40 as on the order paper. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. Amendment 520, which has already been debated, but Dr. Tidball is not here, so that is not moved. Bear with me. Amendment A to Amendment 520 to clause 40 as on the order paper. That's very perceptive. You pointed out to me that the amendment hasn't been moved, so the amendment can't be moved on. Amendment 393 to clause 40, which has already been debated with 392. Kim Leadbeater to move formally.
Move formally, Chair.
Amendment 393 to clause 40 as on the order paper. The question is, that amendment been made? As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. We now come to 527 to clause 40 in the name of Danny Kruger, which has not been grouped with any other amendments. Danny Kruger to move amendment 527, please.
Right, thanks, Sir Roger. This is a period of the season of consensus is over. I'm back to opposing. No, I want to just to... We've had this debate in a sense. This amendment would insist that any remuneration for taking part in assisted dying on behalf of the medical profession would not enable a system whereby a medic or practice would, or private provider would be remunerated according to approving the different stages of the process. We're trying to prevent there being any incentive in the system for moving people through it. And I think there is a real concern. We know that there can be a paid private service delivered under this Act. The concern is that we will create perverse incentives in the system which will prejudice objective decision making. And I take the points about the disinterested good faith of all medics. Nevertheless, I don't want to put them to the danger of feeling the pressure of perverse incentives. And I think it is important that we recognise the importance of keeping absolute financial neutrality in the operation of the bill. So I think there would be significant ethical red flags about a system which essentially enabled performance-related pay tied to approving requests for assisted dying, let alone from paying doctors to provide referrals to a coordinating doctor, for instance. And at the moment, I don't see the bill prevents that. And even if there was no such danger, I'm not sure that patients would buy it. And therefore, I think from the point of view of trust in the medical profession and trust in any doctors that might be involved in this, bearing in mind that any doctor could be involved in this, because any doctor could either raise the suggestion or would be required to signpost a patient who raised it themselves. The whole of the NHS is essentially implicated in the system which is being proposed here. As the Honourable Member, the sponsor, has reiterated today, she wants assisted dying to be an integral part of the NHS. Well, let's protect the NHS from the distrust of patients by ensuring that financial incentives are not in the mix for these life and death decisions. Thank you.
Amendment 527 to clause 40 as on the order paper. The question is that amendment be made.
If I could very briefly answer the honourable gentleman. Although I sort of see his ideas and points here, I think there's no... what will be paid for here is the assessment, and I know no medical process where the outcome is paid for rather than the assessment. So, although I can see that his concerns are real, I do not believe that. Certainly.
Sorry to cut him off in mid-flow. The Honourable Member said he can't understand when the outcome will be paid for. Well, perhaps not the outcome, paying for death, for a dead body. I agree with that. But there could well be payments for the process leading up to that, and that, of course, is the way medical payments work at the moment. So you might get paid for the assessment, then you get paid for the second assessment. You might get paid for the administration of the drugs. You do get paid in the NHS for actually delivering a treatment. Why shouldn't that be the case here?
Well, thank you. I thank the honourable gentleman. I understand his concern, but it's just not the way that medicine works, because the doctor is under a code of practice. So if he's seen to be lying about assessment of capacity or coercion, for example, to enable the fact that he can approve the decision and then go on to assist the dying, he would be well outside his code of practice, and he would be referred to the GMC and in those cases struck off from the medical register. So although I understand the reasons for the amendment that he brings, I don't feel that it is necessary in this part of the primary legislation.
Thank you, Chair. I understand somewhat where the honourable gentleman is coming from, but I think that people have to be paid for time worked as a fundamental matter, and I feel like an interpretation of the honourable gentleman's amendment is that people would not be able to be paid for time worked. It's not about performance-related pay, as he suggests with that continuation of some of his, I would suggest, scaremongering theme from before, but remuneration for time worked. If someone, for example, is referred for an additional capacity assessment, it's right that the person doing the additional capacity assessment is paid for the time worked, not as an incentive, but as a normal payment for time worked. And I think this is poorly drafted and not workable at all, and therefore I will be opposing.
Thank you, Sir Roger. Amendment 527 is linked to clauses 5 and 8, which define who can and cannot be a coordinating or independent doctor. According to clauses 5 and 8, a person who benefits financially from the death of the person cannot be a coordinating or independent doctor. As the bill currently stands, clause 40, subsection 4, provides that a registered medical practitioner is not to be regarded as benefiting financially or in any other material way from the death of a person by reason only of the practitioner receiving reasonable remuneration for the provision of services in accordance with the bill. Amendment 527 may broaden what is meant by benefiting financially, so that its effect may be to prohibit a person from being a coordinating or independent doctor if their remuneration is greater for applications that are accepted than ones that are rejected. However, as drafted, it's not possible to determine the effect of this amendment with certainty, and would therefore require likely require further amending at a later stage should the committee accept this amendment. Thank you, Sir Roger.
Kim Levin.
Thank you, Chair. I won't risk testing the patience of the committee by repeating the comments from my honourable friend, the member for Sunderland Central and the Stroud, and indeed the Minister, but I'm comfortable that clause 40, subsection 4, as it stands, is perfectly acceptable in talking about the remuneration that a doctor can receive, and as such I
would she give way?
I won't be supporting the amendment.
Danny Quinn. To wind up the debate.
Well, I'll just conclude from that, Sir Roger, that the sponsor and the Minister would be content with an arrangement whereby a doctor was paid more for accepting a application and for processing it and for referring a patient on. Suddenly the debate is occurring. Happy to give way.
That absolutely isn't what we've just said.
Well,
Andy Kruger.
In opposing my amendment, the member is declaring himself content with the text as it is. The text as it is would allow a doctor to be paid more the more applications that they receive, process, refer on. It might not be in her mind how the system should work. I'd be grateful to know how the system should work in her mind, because it's not in the bill or in the amendments we've had. We have a very vague arrangement here whereby a private provider would be enabled to deliver assisted dying. Indeed, a profit-making organisation would be able to manage the entire process from beginning to end, referring for I will in a moment, referring for a second assessment to another part of their own company. And the potential is, as would happen in other parts of healthcare, I mean in genuine parts of healthcare, whereby the more work you do, the more money you get. My concern is that that induces a very dangerous incentive into the system. It would be much safer if there was a global fee paid to a provider who managed this service. And the crucial point is, as my amendment would do, we prevent people being paid for approving and enabling assisted deaths. Now, did an honourable member want to come in from the back? No.
Yes, did the honourable member give way? I think he would. I appreciate the point that the honourable member is trying to make, and I think it's a fair one. But may I ask him how he thinks this could work? If you appreciate the principle that people get paid for time, and as he himself in his own intervention said, you might have to get paid for one part of the process than the next part of the process, and inevitably, then there is more money as the process goes on. So can he explain how his would even work?
I'm grateful, and I do actually intend to come in due course in subsequent one of the new clause debates to try and explain how I think we should have done this. But the answer to the honourable gentleman's question is, the way it should be done is that an organisation should be resourced, I think, through philanthropy rather than through taxpayers' money or through people paying out of their own pocket, but however we resource it, to deliver the assisted dying service. The crucial point is they should not be paid more per service, as it were, per treatment, per customer. We shouldn't have the concept of customers in this arrangement. So there should be a provider who is resourced to deliver this service. The crucial point is they should not be paid more per client or indeed for progressing people through the system.
I'm grateful to the honourable member for giving way. That was the exact point I was about to raise. Is there another amendment needed to, if there is a provider who provides this service, then they are not given more money if the person goes through the process rather than the other way around? So yes, thank you.
Yes, I'm grateful, and that is the purpose of my amendment here. So,
Would you give way?
Happy to wait.
Just briefly, I think he's making some interesting points, but I just don't think that's the point of this amendment, because this amendment talks about the doctor being given more money for approving the request, which isn't quite the same point that he's making.
Well, I imagine that the doctor who works for this non-profit service that I'm envisaging, would be paid a salary and would do their work, but not be paid on a per-client basis. They would not be paid a tariff for the number of people that they pass through the system, let alone for the different chunks of the process. So people will need to be paid, but they shouldn't be paid on a per-client basis, because that induces dangerous incentives into the system. Happy to give way to the
and I do think he's making an interesting point, particularly related to the commissioning of this service. And within the NHS, we generally commission on a block basis, where there is a fee per service or a fee per activity basis. And I can entirely see that it would be appropriate for this to be commissioned on a block basis, and I'm happy to work with him at report stage to make that the case. That's not what this amendment says, though. It talks about payment for individual doctors, which gets into the issue that that was referenced to, around people being fairly paid for their time. So I just invite him to collaborate at report stage on the commissioning arrangements rather than this amendment.
Well, we can distinguish between the organisational income and the specific doctor's income, but the same applies in both cases, in my view. But explicitly for the doctor who's making the decisions, they should not feel the pressure of or the temptation of financial reward to expedite or to approve applications for assisted dying. But I'm grateful to the honourable gentleman's invitation, and by all means let's try and make sure that if this we'll get to report stage, that we can try and ensure that we remove the danger of the perverse incentives in the way that the service is commissioned. I think that'll do for me, Sir Roger.
Amendment 527 to clause 40, as on the order paper. The question is, that amendment be made?
Thank you.
The question is, that amendment be made?
Aye.
If any of that opinion, say aye.
Aye.
Contrary, no. No. Division.
Lock the doors.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Lambos Cheryl Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Morthouse.
No.
Sarah Olney.
Aye.
Dr Simon Oper.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Robert. Naz Shaw.
Aye.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tidwell.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it. Unlock. Question is that clause 40 as amended stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. The question is that clause 41 stand part of the bill. Kim Leadbeater.
I beg to move.
Question is that clause 41 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. We now come to Amendment 546 to Clause 42, which has already been debated with Clause 35 stand part. Kim Leadbeater to move the amendment formally.
Move formally, Chair.
Amendment 546 to Clause 42, as on the order paper. The question is that amendment be made. Many of that opinion say aye. Aye. Contrary, no. The ayes have it. Amendment 547 to Clause 42 in the name of Kim Leadbeater, which will be convenient to consider. Amendments 531, 488, 489, 548, 536, 535, 490, Clause 42 stand part and Clause 43 stand part. Kim Leadbeater to move Amendment 547.
Thank you, Chair. I will stand to speak to my amendments 548 and 547. Amendment 548 in my name is not one I had hoped to table, but is one that I recognise is necessary. It's important that we are clear what it says and what it does not say, though. It creates a 4-year backstop, meaning the provisions of the Act must be implemented within 4 years of it receiving royal assent. What it does not say is that it cannot be implemented sooner than that, and I hope and I believe that it can. A backstop is not a deadline. Honourable members who have been in this House longer than me will be very familiar with the idea of a backstop. In this, as in previous contexts, it is not there with the intention that it is seen as the desired outcome, but as a form of protection. The bill, as originally drafted, provided that if all its provisions had not been brought fully into force after 2 years, they would come into force at the end of that period. This will now be the case for 4 years. Chair, I cannot pretend that I am not disappointed about extending the commencement period, and I know that I'm not alone. When I started working on the bill, I remember thinking, gosh, 2 years to implement it, that's a long time to leave the law uncorrected. And how many terminally ill people will face the trauma and expense of travelling to Switzerland, or feel they have no alternative but to take their own lives, or suffer a deeply traumatic death as a result of their illness in that time? How many more families will face the possibility of a police investigation, or have the happy memories of their loved ones tainted by their final weeks or days due to the impact of their terminal illness? And it sat very heavily with me. But, Chair, I thought then, and I still think now, that however difficult it feels at times, this is not a process which should be rushed. It is more important to do this properly than to do it quickly. And I'm pleased to say that this committee has provided the bill in many ways, has improved the bill, in many ways, and added extra safeguards to what was already the strongest assisted dying legislation in the world. In particular, the setting up of a whole new judge-led voluntary assisted dying commission with multidisciplinary panels to look at every application. Inevitably, this will take longer to implement than simply referring cases to the High Court, an institution that already exists. The reporting and monitoring mechanisms and infrastructure, along with the comprehensive training programme we've quite rightly discussed at length in committee, will take time to put together. And it's clearly important to dedicate the necessary time to implementing these important safeguards. But I also know the upset and disappointment many people will feel as a result of a potentially longer commencement period. So it's with some reluctance that I would ask the committee to support Amendment 548. But as I've said, 4 years is very much a backstop. It is not a target. And I, for one, and I know I will not be alone, if this bill passes and receives royal assent, will hold the government's feet to the fire to ensure that its provisions are put in place as quickly as is practicable and safe to do so. To that end, I've also tabled Amendment 547, which ensures that the Voluntary Assisted Dying Commissioner will be appointed within 12 months of the Act passing, and new Clause 40, as previously debated, which confers a duty on the Secretary of State to report to Parliament at that 12-month point and every 6 months thereafter until it has been fully implemented. I think these are important steps to show progress and demonstrate accountability and transparency. Chair, at lunchtime today, I met a group of people representing thousands of others, many terminally ill themselves, who are looking to this Parliament to finally offer them or their loved ones the choice and dignity of a better death. I know, because they've told me, that they are disappointed by this change. I said to them that I would not have made it if I wasn't persuaded it was necessary. But I also said that I will do everything I can to not keep them waiting a moment longer than we absolutely have to. So with that, I hope the committee can support these amendments.
Yeah. Amendment 547 to clause 42, as on the order paper proposed. Question, is the amendment been made? Sarah Olney?
Thank you, Chair. I wish to speak to my amendments 531, 535, and also the amendment in the name of my honourable friend, the member and constituency neighbour, the member for Twickenham. I welcome what the bill sponsor has just said about needing more time to get this right. As I said earlier in this evening's session, there is still so much that has been left to secondary legislation. I regard that in itself as unsatisfactory, but the fact that we're going to take time to get it right will surely go some way to mitigating some of the concerns that people will have about that. I've heard it raised around the estate on a number of occasions today, the concern that the 4-year gap between passing the legislation and implementing the legislation will take us right up to the the next general election. And I have to say, I share people's reservations, even though I'm not a member of the party of government, about quite how the general election campaign will intersect with the implementation of this legislation. And I share people's fears that this whole process then gets very meshed in party politics, which is something that we've hitherto, I think, been able to avoid within the committee, but nevertheless creates a real danger, I think, for successful implementation. I do think that the auto-commencement of this Act after 2 years was a little bit reckless, and so the extension to 4 years does at least permit some potential improvement in palliative care, which is just to reignite the spirit of consensus is something that we all want to see. But an NHS that is already grappling with long waiting lists and staffing shortages could buckle under the added burden of implementing a complex new framework, leading to rushed or inconsistent application. So an automatic commencement of the new laws, regardless of the situation within the NHS, would potentially leave patients and healthcare workers unsupported. But what's important is before the moment comes, whenever it comes, Parliament should be fully informed as to how the service will be provided and the strength of other provision, such that MPs can be confident that those choosing to end their lives through this service are given a fair choice and are not being pushed down a single pathway. We must also have confidence that the medical professionals and panels involved have received adequate training. So the amendment in my name, Amendment 531, ensures that at least we will go into this with our eyes open and that the shortcomings are going to be flagged if not addressed. This amendment would provide that the critical provision of the bill, without which assisted dying cannot lawfully operate, do not come into force until a report setting out the readiness of services to be provided under the Act and that the training has been provided. And similarly, the Maskell 488 amendment mandates a statement of both houses confirming that all necessary regulations are in place, preventing a premature rollout without clear rules. These steps don't halt progress, they will ensure that we are ready to proceed. Finally, there's Amendment 490 in the name of my honourable friend, the member for Twickenham, and this amendment does two very important things. Firstly, it requires that if the Secretary of State wants to commence before the auto-commencement deadline, then they must publish a report covering the same matters as are covered by the report under Clause 35. So this would not be a new requirement, but would instead bring it forward. And crucially, that report will include details about the provision and availability of palliative care services in England and Wales. Secondly, and this is where my honourable friend's amendment goes further than my Amendment 531 and Amendment 488, it requires that regulations bringing the Act into force prior to the auto-commencement deadline use the affirmative procedure. In other words, that there will be a vote in Parliament. This stands to reason if the Secretary of State wants to go quicker than the 4-year deadline that they have, then Parliament ought to be able to consider whether all the necessary preparations have been done and to refuse early commencement if that is not the case. Now, none of Amendments 480, 490 or 531 interfere with the auto-commencement point in 4 years' time. If 4 years is reached, then the whole scheme will come into force and those amendments will not prevent that. But what they do achieve is greater oversight and accountability if the Secretary of State decides to commence early. So I hope that even if the member in charge is not minded to accept striking out the auto-commencement provisions, she will still accept these amendments. Happy to give way.
On that point, I think she's making some very fair points, but I think my amendment at new clause 40, the reporting on the implementation of the Act, would cover the points that she's making.
I'm grateful to her for that intervention. However, I think the crucial point is the vote in Parliament, that that MPs still get an opportunity to consider whether or not sufficient progress has been made, as per her new clause 40, but that there is also a vote to confirm that MPs are content for legislation to proceed.
Obviously, I'm sure the Honourable Lady understands that a vote of that nature would not necessarily be binding or compel the government to do anything, but there would be other opportunities for the House to consider in debate and then vote on that, whether it's via a backbench motion or an opposition day, or there are a number of ways, as she knows, that members can do exactly that.
Sarah Alderman.
Well, I'm grateful to the member for his intervention. I think, just referring back to my earlier comments, there are few enough opportunities for MPs to have any further control over how this legislation is going to be implemented. I don't think it's asking too much for an opportunity, a further opportunity to be mandated in this way and not to be left to the vagaries of, dare I say, the backbench business committee or whichever other, and dare I say, opposition days. You're absolutely right, but this is a cross-party, this is a conscience issue, and I can only speak for my own party, but I think there are a number of other issues that they would want to use their opposition day debates to address. So taken together, they ensure that Parliament is properly informed if the Secretary of State decides to commence the scheme before the 4-year auto-commencement deadline. I want to address the issue of how this bill is going to be implemented in Wales. In anticipation of this bill being published on the 23rd of October 2024, Senator Cymru debated a motion calling on the Welsh Government to A, support the principles of assisted dying, and B, support Westminster Parliament to introduce a compassionate assisted dying law in England and Wales. Now, the motion was defeated 19 to 26, and among those who voted against were a number of Welsh Government ministers, including the First Minister, Ellen Ed Morgan. And I believe that all three of the political parties, Labour, Plaid and Conservatives, there was a majority against. And in this context, as Professor Emma Lewis, who gave evidence before us, said, it would be constitutionally wrong to pass this bill without the consent of the Welsh Senate. He says that this is different from other instances where legislation has been passed by Westminster against the will of Wales. And I quote, this is not the equivalent, for instance, of trying to rebase the UK's internal markets following the chaos of Brexit. When the UK Parliament passed acts ignoring refusal of consent from Cardiff or Edinburgh, it did so in what were considered to be the interests of the economic coherence of the UK. Now, this bill is a different sort of creature. It is a bill which would bring about a profound change in the law relating to life and death, where there are strongly held and expressed moral, religious and cultural views against as well as in favour. How can it be constitutionally appropriate for the UK Parliament to pass such a bill for Wales when the Senate has indicated its opposition by democratic vote after a thorough debate?
On that point, I thank you for giving way, and I think hopefully she can acknowledge that the vote that took place in the Senate was very, very different to the piece of legislation before us in Parliament. And hopefully I can reassure her, as I have done previously, that I am in contact with the Senate and will be meeting with Welsh ministers, along with new clause 37, which I hopefully provide some reassurance in terms of issues around devolution.
I'm grateful to the member for her intervention. Again, referring back to what I said earlier, I fear this is another example of where instead of debating and agreeing these things in committee or in Parliament, we are delegating this to be decided elsewhere by some other people, and it is not. It is not, therefore, the legislation that we are debating and voting on in front of us. But I just want to reiterate the point. The Senate has already made its view clear. It may not have been a binding vote. They may not have been voting on this specific piece of legislation. However, I think the will of the Senate is clear, that they don't want an assisted dying bill that's going to be imposed upon them, and that is what the evidence of Professor Emma Lewis told us.
Yeah, I think that's a very inaccurate representation of the vote that took place in the Senate.
Sarah?
I'm sorry she feels that. One possibility is to seek to respect devolution strictly by either changing the law or giving the power to the Secretary of State to change the law in respect of what is reserved. Sorry, I beg your pardon. I'm aware that the complicating factor here is that the criminal law is not devolved to Wales, but health is, as is safeguarding. So one possibility is to seek to respect devolution strictly by either changing the law or giving the power to the Secretary of State to change the law in respect of what is reserved, while giving to the Welsh ministers the powers in respect of what is devolved. The problem is that the bill does not, even with the amendments which have been tabled by the member in charge, quite do that. Those amendments fail to properly identify what is and what is not devolved, and instead kicks the can down the road. Future litigation might be required to figure out the precise boundaries. For example, regulation of health professionals is a reserved matter, but adult safeguarding is a devolved matter. So is the training of those health professionals on spotting coercive control a reserved or a devolved matter? The bill does not answer this question. The solution, therefore, carries a real risk. If Wales decides that they do not want assisted dying and therefore do not provide it on their NHS, and the Welsh ministers decide not to set up proper training and regulatory programmes in respect to the safeguarding issues raised, then the position in Wales will be that it would be decriminalised, and so this service could be provided by private providers charging a fee and not necessarily properly trained in safeguarding. Now, that is not a sustainable middle ground, and so would naturally pressure Wales to move towards commissioning such services itself. In other words, it either respects devolution at the risk of creating a legal limbo, or it puts pressure on Wales to catch up with England, neither of which are desirable. And another alternative is to take away any choice that Wales might have on the matter entirely and have the law apply in Wales in exactly the same way it does in England, including when it comes to the actual delivery of services. This would avoid the legal limbo problem, but it would come at the cost of acting in a way that is constitutionally quite wrong. So that then brings us to the solution that Professor Lewis proposed in his blog. And I'm quoting, "How then might the bill be amended to respect the Senate's vote on the matter of principle? One straightforward way would be to provide for different commencement provisions in the bill. As things stand, under clause 42 of the bill, most of the bill will not come into force until the Secretary of State has brought it into force with the approval of the UK Parliament. Why not provide that the bill will only come into force in Wales when and if the Welsh ministers bring it into force with the approval of the Senate?" And that is what my amendment seeks to do. I can foresee 3 objections. Firstly, it might be said that the criminal law is a reserved matter and therefore Parliament ought not to refrain from legislating for Wales or have different commencement arrangements for the criminal law in England compared to Wales. But Parliament is sovereign and can do what it wants. By the same reasoning, Parliament should never grant a temporary power to devolve legislate on matters that are normally reserved, and yet Parliament does do that. The second objection might be that England and Wales are a single jurisdiction and that there should not be a difference in the criminal law between them. But this misunderstands that there are already, as a result of the devolution settlement, differences in the criminal law of England and Wales. For example, in our law there is a defence of reasonable chastisement, which means that parents smacking their children would not be committing a criminal offence. While the criminal law is not devolved to Wales, child welfare is, and using those powers on child welfare, the Senate voted to abolish the defence of reasonable chastisement in Wales. So that means that there is a difference in the criminal law of England and Wales. So a position whereby assisting suicide was partially decriminalised in England but fully criminalised in Wales would not be an oddity, and there is no principle of our constitution which says that the criminal law must be the same on each side of the border. The key issue is that the decriminalisation of assisted suicide, which this bill does, is not a standalone measure. It is not, for example, like the Swiss criminal code, which does not criminalise assisted suicide when the person acted for non-selfish motives. Rather, it is a decriminalisation of assisted suicide which is contingent with complying with a detailed healthcare regulatory scheme, i.e. an issue which is devolved to Wales. Finally, it might be objected that this might create difficult cross-border issues. As Professor Lewis put it in his blog, that would be true also if, for instance, the Scottish bill did not become law. Far more difficult cross-border issues were successfully accommodated in the context of legislation also involving profound ethical considerations when the National Assembly for Wales, as the Senate was then called, changed the law on organ donations. Now, such a situation might, I accept, require constitutional amendments in subsequent stages, but these could easily be done by the government at report stage. Ultimately, when one looks at it in detail, having a different commencement provision for Wales is the only practical way of respecting the vote of the Senate while not running the risk of creating a legal limbo. Finally, I would like to draw the committee's attention to the supplementary written evidence of Professor Lewis, where he commends my Amendment 535. Regardless of where we stand on assisted dying, we should respect democracy and the people of Wales through their elected representatives, acting as they should as representatives, have voted against assisted dying. We should respect that choice and not impose it on them, in whole or in part, without their consent. Thank you, Chair.
Chair Bridges. Thank you, Chair. Very briefly, I stand to speak in support of the sponsoring member's Amendment 548. I do so fundamentally for 2 reasons. Firstly, as many members of this bill committee, indeed members of the House, there may be a lot of support for the principle of assisted dying, but there are understandable concerns about its implementation. And we have been debating all the aspects of that over a lengthy period of time in committee, and it is undoubtedly complex. And although the sponsoring member is disappointed that she's put forward this amendment, I commend her, because actually it's more important to get this right and be brave in setting longer time limits if that's necessary, and I think that can be reassuring to members who, while support the principle, want to make sure that we get this right, and I hope that this amendment will do that. And secondly, for those, indeed, people who have been in the public gallery today who might be disappointed about delay, members of this committee, indeed other members of the House, in my mind, this is not an obstacle to change. In fact, what we have seen here is a sponsoring member working with the government, who remain neutral in the principle but want to make this deliverable, coming up with a sensible, pragmatic proposal as to how and at what speed this profound change is to be implemented. In my mind, that gives a sense of the executive and the sponsoring member thinking about the practicalities of this. And for those that are desperately seeking this change, who have fought for decades and decades, I urge them to approach that with a sense of optimism, that this is serious. This is a once-in-a-generation opportunity to deliver that change. And I hope that they will, in committee now, but then outside of committee, support the sponsoring member, who's gone to great lengths to build support, but also to make sure that this bill is workable. So I will be voting for that amendment with a great sense of reassurance, but also a great sense of optimism that that one day this country will see this change that's so desperately needed.
Thank you very much, Chair. I rise in support of Amendment 535. I don't intend to say much more because the honourable member for
Richmond Park.
It's almost 10 o'clock. It's almost 10 o'clock. Has said many of the points I wish to make, but this, of course, does recognise the fact that there has been a view stated, an opinion stated in a debate in the Senate last autumn in October, which dealt with in detail the principles of this bill that we are discussing here. And Professor Emma Lewis told us that one of the ways of recognising this would be to consider different commencement provisions in Wales. The phrase that I want to use now, because the reference has already been made to different criminal law arrangements to do with smacking children, different laws over the border between England and Wales. And also, of course, during the COVID time, that there were different arrangements between England and Wales, quite definitely different. What we do have now, of course, after a quarter of a century of the existence of devolution is devolution divergence. And we're seeing this in action. But the one point I really want to make, I think, and because we've already accepted the principle that there are aspects of this bill which are devolved, the responsibility for which must be passed to Welsh ministers. We're debating still the wording of that, but we're working towards it. I think we've accepted the principle of it. But I think we should also acknowledge, actually, that this is a move, therefore, that the Senedd and Welsh ministers may well be able to do, which will have the same effect of changing the commencement date. But also I support this because it shows, I support this amendment because it shows that we are acknowledging the consequences and the implications of a legislative consent motion, which, of course, incidentally, of course, I could often stand up here and talk about the fact that legislative consent motions actually can be overridden by Westminster. But we are working from a point of view where we are seeking to respect devolved powers alongside the powers that we have here. So I will be supporting this amendment.
Tom Gordon. Thank you, Sir Roger. It's an honour to serve the chairmanship. I'm rising to regretfully speak in opposition to Amendment 548, which would seek to extend the implementation period from 2 to 4 years. I'd start by saying that the member in charge I have complete and utter admiration for throughout this process. And I appreciate that she said herself that it's one of disappointment that she's had to table this. And a lot of what she said already, I'll echo throughout what I say now. We're here today because we acknowledge that there is an injustice, that the current law for assisted dying is failing people. It forces people who are terminally ill in unbearable pain to make impossible choices. It compels them to travel overseas, away from comfort of home, to die in unfamiliar surroundings. It punishes those grieving families by forcing them to endure police investigations for simply standing by their loved ones. And it denies dignity in death and peace in grief. We've recognised that as unacceptable, and that's why we're here debating this bill. And yet this amendment and this delay would seek to tell those same people that they must wait. People have already been waiting far too long. Their suffering is not seen as important enough, and their right to a peaceful death has to be postponed. It's not justice, and we mustn't allow it. We know the British public overwhelmingly support a change in the law. People want to see assisted dying laws in place during this Parliament, not in some uncertain future. They will not accept delay, and I don't think they'll be particularly forgiving of excuses. If we allow the implementation period to be extended to 4 years, we are effectively seen to be kicking the can down the road. And I know comments have been made about how the implementation would potentially be before the next general election, but there's no guarantee or certainty of that. We know that it's with the gift of the Prime Minister for when that next general election is called. And I cannot think of a more worrying instance of a change of government having to implement a big societal change. And that's something that this amendment could make a possibility. And we also know that no Parliament can bind the next, and that the legislation that's been passed but not enacted and put in place could be quickly abandoned. We can't allow that to happen. The cost is too great, and for people out there who've been campaigning for years, that would be an absolute catastrophe. It's not an abstract policy debate. It is about real people who are suffering right now who can't afford to wait. And there are a number of people who've been in touch who've made their voices and views clear on this amendment. One, Tim Wardle, a terminally ill man from Devon with bladder, prostate and lung cancer, said, and I quote, "Even a slight delay beyond the 2 years currently proposed is not fair or reasonable. I hope the proposal is defeated." And Claire Turner, a mother of 2 with stage 4 breast cancer, has even made it clearer, saying, quote, "This is outrageous for terminally ill people like me. Every delay means more suffering, more people forced to endure unbearable pain against their will. This government needs to stop dragging its feet and act now." And I appreciate it's not this government that's enacting that bill. But that's reality, and as uncomfortable as it is to hear those stories, we must hear them, and we must listen. And it's not just people who are terminally ill too, who are anxious about having a change in law. I've endlessly throughout this bill committee and process, every single time that I speak to my mum on the phone, she asks me how it's going, she asks me what the process is, she asks me what the end date will be. And that's because it popped up on Facebook yesterday that it was actually 8 years ago that she received her all clear from breast cancer. But the reality of getting that all clear is that it still hangs over her. Now, when she was diagnosed with breast cancer, she had 2 independent tumours, and her mum, my gran, and her sister, my aunt, both had breast cancer. And while there was no genetic testing to show that it was something that there was a genetic link there, the doctor almost certainly said, this is probably going to come back and you'll probably end up with breast cancer again. Now, my mum had PTSD from that experience of going through cancer treatment, through that mastectomy, through that recovery, prolonged and still to this day complications as a result of that procedure and that chemotherapy. It was entirely traumatic on the family. And my mum's long said that if she was to have to go through something like that again, or whether she ended up with secondary breast cancer at a later date, that she would want this option. So every time I speak to her, she's been really, really heartened to hear the progress that the Bill Committee have been making on this. And when we speak about this delay, it's absolutely crushed her heart. And mine too. And just having that option would set her anxiety, as someone who doesn't have a terminal diagnosis or necessarily anything just yet, it would set her to peace as well, giving her that comfort. The supporters of this amendment will say that we need 4 years to get this right. But I want to know where the evidence for that claim is, and that's something that hasn't been clearly set out. Now, when we look around the world at other countries, they've managed to implement similar laws in far less time. Spain implemented its law in just 3 months after the passage of the bill. Jersey and the Isle of Man are aiming for an 18-month implementation period. And indeed, no other country around the world has taken longer than 2 years. The only exception of a particularly protracted and prolonged one was in Oregon, and that was because of legal challenges. We know that the NHS has demonstrated time and again, particularly during COVID, that when there is a need, they can act swiftly and decisively. We know that where we set a deadline, civil servants will work towards it, and we have some of the best civil servants in the world, and I commend them for the work that they do. Throughout this process, we've examined this bill line by line, ensuring it's the strongest, most robust assisted dying piece of legislation in the world. We've strengthened its safeguards, refining the eligibility criteria, and I appreciate that I've had different views to some people on that, embedded rigorous oversight mechanisms, and ensured that every step is guided by medical expertise and input from experts. We have drawn from the best of international practices. We have learned from the experiences of jurisdictions that have successfully implemented assisted dying laws with compassion and care. This is not a rushed or reckless piece of legislation. It is carefully crafted, and it is based on the right to choose with the need for stringent protections. To delay its implementation from 2 years to 4 years after such thorough debate and scrutiny and refinement would undermine the very care and diligence that this bill has been shaped by. Delaying implementation is not simply a neutral decision. It is a decision to prolong that, the lack of choice for people with terminal illnesses. It's a decision to deny them the ability to die on their own terms. It's a decision to force more families into those impossible situations, watching their loved ones suffer, facing investigations for simply accompanying them abroad, being unable to grieve properly because they can't even bring a body home. That is the reality of such a delay, and we do have the power to stop it. So colleagues, we can't allow interference from government or wherever this has come from suddenly at the last moment. And this is my frustration, is that this amendment was tabled at the very last moment without that understanding of where it has come from. We must listen to the people who are at the heart of this bill. We must listen to the public and all the people who have given us that input so far to make sure that we end up with an assisted dying bill that does take into account compassion and doesn't prolong that timetable for those people. And with that, it's with regret that it will be something that I'll be voting against.
Order. I indicated that I was going to suspend at 10 o'clock. But in the interest of continuity, I'm proposing to conclude this clause and then suspend for 15 minutes. Dr. Simon.
I'll be very brief, and I must admit, this is the most difficult speech I've had to make in this whole committee, actually. Look, I'm disappointed. I think we're all disappointed on people that support the bill, and I'm sure that our honourable friend from Fen Valley is also incredibly disappointed too. And I hear that, and I do also believe that this is deliverable within 2 years. But actually, I've listened to these arguments that we have, and I have wanted this legislation to go through for about 25 years of my life, and my main aim here is that the legislation goes through. And I understand from certain dialogues that I've had that the legislation is more likely to go through if we accept this amendment. So therefore, in short, I will support this amendment reluctantly, but with my full support, and I will vote for it. Thank you.
Thank you, Chair. Can I just say, first of all, I'd like to say thank you to the honourable member for Knaresborough and Howger Knaresborough for sharing something which is so deeply personal. And I'm sure I speak on behalf of all the committee members there. We wish your mum well, and that she never has that diagnosis ever. I stand to move, Chair, the Amendment 489 tabled by my honourable friend for York Central, and also Amendment 488, also tabled by the member for York Central. This amendment would prevent the bill's provisions from coming into effect automatically after a certain period had elapsed. This bill, as it was presented to Parliament, had a measure to that effect in subsection 3 of clause 42. The original reads, "But if any provisions of this Act has not been fully brought into force before the end of the period of 2 years, beginning with the day on which this Act is passed, that provision, so far as not already in force, comes into force at the end of that period." The bill sponsor has now brought forward an amendment 548 that would change the wording of this bill so that there would be a period of 4 years rather than 2 after the Act has passed. After that time has elapsed, any provision of the Act that had not been fully brought into force would do so automatically. I believe that a period of 2 years was far too short, and I welcome my honourable friend's decision to extend it to 4 years. But under her amendment, all provisions of the bill not in operation would still automatically come into force after a certain period. That would happen regardless of whether we are sure they can be safely implemented. Such a measure seems to me to have some risk, even if the period has been increased. If we implement assisted dying in this country, it is something that we have to get as right as possible. Mistakes will mean that the state has wrongly provided people with lethal drugs to end their lives. That is not something we should be prepared to tolerate. Amendment 489 would prevent that from happening by removing subsection 3 from clause 42. My honourable friend's Amendment 488 suggests a different approach to bringing all the bill's provision into force. Amendment 488 would replace the current wording of subsection 3. The new subsection would concentrate on how the Secretary of State would make a statutory instrument containing regulations that have the effect of bringing clause 18 into effect. As honourable members will know, clause 18 is that part of a bill that governs the provision of assistance, the part of the process where the person who is authorised to do so actually self-administers lethal drugs. Under Amendment 488, the Secretary of State would only be able to pass statutory instruments putting that part of the process into effect if they had passed a condition. The condition would be that a minister in each of the Houses of Parliament would have to make a statement setting out, and I quote, that in their opinion all regulations necessary for the effective provision of assistance have been made under this Act, and they would also have to list those regulations. This approach is better in several ways. Ministers will only bring the administration of lethal drugs into operation only when they can show and demonstrate to Parliament that there is the right framework for doing so effectively. That would also give members of this House and the other place a chance to question ministers and inquire whether the system already really is ready. That is what regulators call a conditions-based approach. It is surely a far better way of ensuring the system can work than imposing a timeline on ministers which does not ask any questions about readiness. I anticipate that honourable members may say that this approach will excessively slow down the process of the bill coming into effect. But Amendment 548 also slows down that process, so that potentially the bill may only come into full effect after 4 years after it was passed. Honourable members may also say that this approach is too cautious, but every day of our lives we expect different levels of caution in different services and operations. We expect anyone who drives on our roads to be trained to a good enough level to have a driving licence or to be supervised by an instructor, and we expect drivers to carry out basic checks on the mirrors and on the road before they start the car and drive off. But we expect a far higher level of training for someone who, say, flies a passenger plane. We expect aeroplane pilots to carry out a far larger number of checks and to actually answer questions from air traffic control before they are cleared to take off. That is not excessive. It is a common sense approach that reflects that there are far higher risks involved in flying an aeroplane full of people above crowded city than in driving a car. This is the approach that my honourable friend's amendment would take, and I urge members to support it. Thank you, Chair.
Minister.
Thank you very much, Chair. The group of amendments relate to clause 42 of the bill and the commencement provisions. Amendment 547, in the name of the Honourable Member for Spen Valley, provides that clauses relating to the Office of the Voluntary Assisted Dying Commissioner under the sponsor's amendment to introduce new clause 14 and new schedule 1 would come into force 1 year after the Act is passed. Subsection 4 of new clause 14, which relates to the functions of the Commissioner, including arranging the work of panels and monitoring the operation of the Act, would not come into force at this point. This amendment would require the process of recruiting the Commissioner and their deputy to begin shortly after royal assent. Powers to second staff under Schedule 1 may be a necessary tool in resourcing the Commissioner in the interim period before the wider Act would come into force. 531 would require the Secretary of State to lay a report before Parliament before assisted dying can be provided and assisted dying is decriminalised. This report must contain an analysis of the readiness of services to provide assistance and an analysis of the training that's been provided under this bill. The effect of this amendment may be to delay the commencement of the bill until the specified reports have been laid before Parliament. Amendment 488 removes the current clause 42 subsection 3, which provides that any provisions that are not already enforced 2 years after the bill is passed come into force at that point. This would mean that the Secretary of State would need to make regulations to bring all provisions of the Act into force except sections 37 to 41 and Section 43, which come into force when the Act is passed. In addition, the amendment provides that Section 18 may not be brought into force until a Minister of the Crown has made a statement to both Houses of Parliament that all regulations necessary for the effective provision of assistance have been made. The Minister's statement must list those regulations. The amendment does not specify which regulations are necessary for the effective provision of assistance, and so this could create uncertainty. Amendment 489 is linked to 488, again removing current clause 42, subsection 3. Turning to Amendment 548. As I've set out, as the bill currently stands, the provisions will automatically come into force 2 years after the date the bill passes, where they have not already been brought into force. Amendment 548, brought forward by the bill sponsor, which was drafted with the technical support of government officials and lawyers, would change this provision in the bill from 2 years to 4 years. We have already discussed the proposition to have regular reports on progress towards implementation as per Amendments 546 and new Clause 40. The time required to prepare for the implementation of the bill is clearly a critical point to be weighed when considering the question of workability. Were Parliament to approve the provision of assisted dying services, it would be the role of government to ensure that a fully functioning, safe and high-quality service is in place for those who wish to access the assistance provided for under the bill. The delivery of an entirely new service with robust safeguards will need to be carefully and thoroughly developed and tested. As the bill has rightly been amended by the committee members during committee stage and several new requirements have been added, the government will now have to assess the critical path to implementation. We will therefore provide clarity to members ahead of report stage regarding whether any further amendments related to commencement are needed. We will continue to develop our thinking on this matter and will work with the bill sponsor to explore the potential options for report stage to capture both the need for timely implementation and for ensuring the provision of a high-quality service for people seeking assistance as set out in the bill. Amendment 536 would increase the length of time specified under 42.3 from 2 years to 5 years. This would mean that any provisions of the bill which had not been commenced before the end of the period of 5 years beginning with the date the bill is passed, they would automatically come into force at that time. 535. As the bill currently stands, the Secretary of State may make regulations to commence the provisions of this bill for England and Wales. This amendment would, in relation to Wales, require the Welsh ministers to commence the bill via regulations instead of the Secretary of State. This means that, apart from clauses 37 to 41 and 43, which would come into force on royal assent, the provisions of the bill would come into force in Wales on a date or dates appointed by the Welsh ministers in regulations. This amendment means that there would be no automatic 2-year backstop for those provisions to come into force in relation to Wales. This amendment also makes regulations made by the Welsh ministers to be subject to the affirmative resolution procedure in the Senedd. This may have devolution settlement consequences, as the impact of this amendment could be that the bill is differentially commenced in England and Wales, potentially creating disparity, particularly in relation to the introduction of the criminal offences and lack of certainty. 490. As the bill stands, regulations made under 42.2 are subject to the negative resolution procedure. This amendment would change the regulation-making procedure, and the Secretary of State may not make commencement regulations unless a draft of the regulation has been laid and approved by each House of Parliament. The amendment also adds a new requirement that the Secretary of State may not lay a draft of regulation until until they have laid a report before each House, which provides an analysis of the expected efficacy of services and functions performed under this bill. The amendment provides a non-exhaustive list of the information the report must contain. This amendment could cause delays to making commencement regulations under the bill. Thank you, Chair.
Kim Levitt.
Got nothing further to add, Chair.
Amendment 547 to clause 42. As on the order paper, the question is that amendment be made. As many of that opinion say aye.
Aye.
Contrary, no. Ayes have it. Ms Savile Roberts, not moved.
It's one of the series of amendments.
Amendment 531 to clause 42, which has already been debated with 547. Zolny, do you wish to move it formally?
I'd like to move, Chair.
Amendment 531 to clause 42, as on the order paper, the question is that amendment be made. As many of that opinion say aye.
Aye.
Contrary, no. No. Division. Block the vote.
Jack Abbott. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Dan Lambert.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger. Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul. Aye. Jake Richards.
No.
Sarah Sackman.
No.
Liz Seville Roberts.
No.
Naz Shah.
Aye.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tipple.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it. Unlock. We now come to Amendment 488, Clause 42, already debated at 547. Does anyone wish to move 488 formally? Not moved. We now come to Amendment 489 to Clause 42, which has already been debated with 547. Does anybody wish to move Amendment 489 formally?
Formally, Chair.
Amendment 489 to Clause 42, as on the order paper. The question is that amendment be made. As many of that opinion say aye?
Aye.
Contrary, no?
No.
Division. Lock the doors.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Dan Lambert.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater. No. Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul. Aye. Jake Richards.
No.
Sarah Sackman.
No.
Liz Seville Roberts.
No.
Naz Shah.
Aye.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tipple.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it. Leave the doors locked, please. Amendment 489 to Clause 42, already debated. Does anybody wish to move that formally? Not moved. Amendment 548, I beg your pardon, I've done that. Amendment 548 to Clause 42, which is already debated with 547. Kim Leadbeater to move the amendment formally.
Move formally, Chair.
Amendment 548 to Clause 42, as on the order paper. The question is that amendment been made. As many of that opinion say aye?
Aye.
Contrary, no?
No.
Division.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell.
Aye.
Dan Lambert.
Aye.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. Aye. Rachel Hopkins.
Aye.
Sojourn Joseph.
Aye.
Stephen Kinnock.
Aye.
Danny Kruger.
Aye.
Kim Leadbeater.
Aye.
Kit Malthouse. Sarah Olney.
Aye.
Dr Simon Ofer.
Aye.
Rebecca Paul.
Aye.
Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Seville Roberts.
Aye.
Naz Shah.
Aye.
Dr Neil Shastri-Hurst.
Aye.
Dr Marie Tipple.
Aye.
Sean Woodcock.
Aye.
The ayes were 22 and the noes were 1. So the ayes have it. There is no shame in being in minority of one. Amendment 548 to Clause 42, which has already been debated. Kim Leadbeater to... I've done it. Good. Sorry. 536. Amendment 536 to clause 42, already debated with 547. Does anybody wish to move it formally? No. Not moved. Amendment 535 to clause 42, already debated with 547. Ms Olney, do you wish to move it formally?
I beg to move, Chair.
Amendment 535 to clause 42 as on the order paper. The question is that amendment be made. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell.
Aye.
Lambos Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. Aye. Rachel Hopkins.
No.
Jojan Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger. Kim Leadbeater.
No.
Kent Malthouse.
No.
Sarah Orney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts.
Aye.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
There's one in it, isn't it?
The ayes were 12 and the noes were 11. So the ayes have it. Unlock. Saville Roberts. Not moved.
Of the series, yeah.
Amendment 490 to clause 42, already debated with 547. Does anybody wish to move it formally? Not moved.
Beg to move. I beg your pardon, Chair, was that 490?
Amendment 490 to clause 42, debated with 547. You wish to move it?
Yes, please. Promise.
Amendment 490 to clause 42, as on the order paper. The question is that amendment be made. As many of that opinion say aye.
Aye.
Contrary, no. No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Lambos Landos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Jojan Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kent Malthouse.
No.
Sarah Orney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul. Aye. Jake Richards.
No.
Sarah Sackman. No. Liz Saville Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8 and the noes were 15, so the noes have it. Unlock. We now come to the question that clause 42 stand part of the bill. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell.
No.
Lambos Lambos.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins. Aye. Jojan Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater. Aye. Kent Malthouse.
Aye.
Sarah Orney.
No.
Dr. Simon Ofer.
Aye.
Rebecca Paul. No. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts.
Aye.
Naz Shah.
No.
Dr. Neil Shastri Hurst.
Aye.
Dr. Marie Tidball.
Aye.
Sean Woodcock.
No.
Thank you. The ayes were 15 and the noes were 8, so the ayes have it. We come to a sequence of pre-debated items. Unless anybody's feeling faint, I'm going to see how we get on. Can I just take some time? Is everybody all right? Okay, let's give it a whirl and see where we get to. If I fall over, somebody else will have to come and take the chair. Right, okay. Order! The question is that clause 43 stand part of the bill. It's already been debated. The question is clause 43 stand part of the bill. As many of that opinion say aye? Aye. Contrary no? The ayes have it. New clause 8 already debated with 187. Kim Leadbeater to move formally.
Move formally, Chair.
The question is that the new clause be read a second time. As many of that, I beg your pardon, it's you.
Duty to consult before making regulations.
I knew I was going to stop you from speaking. The question is that the new clause be read a second time. Does many of that opinion say aye? Aye. Contrary no? The ayes have it. We now come to new clause 14, which has already been debated with new clause 12 stand part. Kim Leadbeater to move formally.
Move formally, Chair.
Voluntary assisted dying commissioner.
The question is that the new clause be read a second time. As many of that opinion say aye? Aye. I think the ayes have it. I beg your pardon. Try again.
Great, Chair. Good try, Jim. Nice try.
Get away with some. Right. We'll try that again and again. The question is that the new clause be read a second time. As many of that opinion say aye? Aye. Contrary no? No. Division.
Jack Abbott.
Sorry, Chair, I didn't hear which one you were on. Sorry.
New clause 14.
New clause 14.
Apologies. Aye. Aye.
Lewis Atkinson.
Aye.
Juliet Campbell.
No.
Campbell Sharon Ambrose.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins. Aye. Surgeon Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kent Malthouse.
Aye.
Sarah Olney.
No.
Dr. Simon Ofer.
Aye.
Rebecca Paul. No. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts.
Aye.
Naz Shah.
No.
Dr. Neil Shastri Hurst.
Aye.
Dr. Marie Tipple.
Aye.
John Woodcock.
No.
The ayes were 15 and the noes were 8. So the ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye? Aye. Contrary no? The ayes have it. We now come to new clause 15, which has already been debated with clause 12 stand part. Kim Leadbeater to move formally.
Move formally, Chair.
Referral by Commissioner of Case to Multidisciplinary Panel.
The question is that new clause be read a second time. As many of that opinion say aye? Aye. Contrary no? The ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye? Aye. Contrary no? The ayes have it. New clause 17 has already been debated with clause 12 stand part. Kim Leadbeater to move formally.
Move formally, Chair.
Reconsideration of panel decisions refusing certificate of eligibility.
The question is that the new clause be read a second time. As many of that opinion say aye? Aye. Contrary no? The ayes have it. I beg your pardon. I call Rebecca Paul to move Amendment A to new clause 17. Question is that Amendment A be made. As many of that opinion say aye? Aye. Contrary no? No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
No.
Campbell Sharon Ambrose.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shah.
No.
Dr Neil Chestry-Hurst.
No.
Dr Marie Tidball.
No.
Sean Lidcock.
No.
The ayes were 3 and the noes were 20, so the noes have it. The question is that new clause 17 unamended be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no?
No.
Division.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell.
Aye.
Bamble Shower-Lambert.
Aye.
Daniel Francis.
Aye.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins.
Aye.
Sojourn Joseph.
Aye.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
No.
Dr Simon Ofer.
Aye.
Rebecca Paul. No. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts.
Aye.
Naz Shah.
Aye.
Dr Neil Chestry-Hurst.
Aye.
Dr Marie Tidball.
Aye.
Sean Lidcock.
Aye.
The ayes were 20 and the noes were 3, so the ayes have it. New clause 19 has already been debated with Amendment 345. Kim Leadbeater to move formally.
Move forward, Chair. Recording of preliminary discussion.
The question is that the new clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. New clause 21 has already been debated with Amendment clause 12 stand part. Kim Leadbeater to move formally.
Move forward, Chair. Determination by panel of eligibility for assistance.
The question is that the new clause be read a second time. As many of that opinion say aye. Aye. Contrary, no.
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 Division. Voting on this.
21.
That's right. It's okay.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell.
No.
Bamble Shower-Lambert.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins.
Aye.
Sojourn Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
No.
Dr Simon Ofer.
Aye.
Rebecca Paul. No. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts. Naz Shah.
No.
Dr Neil Chestry-Hurst.
Aye.
Dr Marie Tidball.
Aye.
Sean Woodcock.
No.
The ayes were 15 and the noes were 8. So the ayes have it. Does any member wish to move Amendment D to new clause 21?
So move formally. I move formally.
You wish to move? Amendment D to new clause 21. The question is the amendment be made. Does many of that opinion say aye?
Aye.
Contrary, no?
No.
Division.
Jack Abbott. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bamble Shower-Lambert.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kent Malthouse.
No.
Sarah Orney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Savile Roberts.
No.
Naz Shaw.
Aye.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 9, the noes were 14. So the noes have it. Rebecca Paul to move Amendment C to new clause 21. The question is that Amendment C be made. Does many of that opinion say aye? Aye. Contrary, no? No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell. Aye. Campbell Sharon Ambrose.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater.
No.
Kent Malthouse.
No.
Sarah Orney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Savile Roberts.
No.
Naz Shaw.
Aye.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it. Does any member wish to move Amendment E to new clause 21?
I beg to move, Chair.
The question is that Amendment E be made. Does many of that opinion say aye? Aye. Contrary, no? The ayes have it. Rebecca Paul to move Amendment A to new clause 21.
I beg to move.
The question is that Amendment A be made. Does many of that opinion say aye? Aye. Contrary, no? No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
No.
Campbell Sharon Ambrose.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater.
No.
Kent Malthouse.
No.
Sarah Orney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Savile Roberts.
No.
Naz Shaw.
No.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
No.
The ayes were 3, the noes were 20. So the noes have it. Rebecca Paul to move Amendment B to new clause 21.
I beg to move.
The question is that Amendment B be made. Does many of that opinion say aye?
Aye.
Contrary, no? No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
No.
Campbell Sharon Ambrose.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater.
No.
Kent Malthouse.
No.
Sarah Orney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Savile Roberts.
No.
Naz Shaw.
No.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
No.
The ayes were 3 and the noes were 20. So the noes have it. The question is that the new clause as amended be added to the bill. Does many of that opinion say aye? Aye. Contrary, no? The ayes have it. New clause 24, which has already been debated with 514. Kim Ledbeater to move formally.
Move formally, Chair.
Falsification of documentation, etc., with intention that another will obtain assistance to end own life.
The question is that the new clause be read a second time. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. We now come to new clause 36, which has already been debated, with amendment 525. Kim Leadbeater to move formally.
Move formally, Chair.
Voluntary Assisted Dying Services, England.
The question is that the new clause be read a second time. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Division.
Jack Abbott.
Aye.
Nose Atkinson.
Aye.
Juliet Campbell.
No.
Ambrose Charon Ambrose.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins. Aye. Sojourn Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kent Malthouse.
Aye.
Sarah Olney.
No.
Dr Simon Oaker.
Aye.
Rebecca Paul. No. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts.
Aye.
Naz Shaw.
Aye. Sorry, no. I'm on the wrong. No.
So is that?
No.
No. Dr Neil Shastri-Hurst.
Aye.
Dr Marie Tidball.
Aye.
Sean Woodcock.
No.
The ayes were 15, the noes were 8, so the ayes have it. Danny Kruger to move Amendment A to new clause 36 formally. Question is that Amendment A be made. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Jack Abbott.
No.
Lois Atkinson.
No.
Juliet Campbell.
No.
Ambrose Charon Ambrose.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. No. Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Oaker.
No.
Rebecca Paul. Aye. Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shaw.
No.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
No.
The ayes were 3, the noes were 20, so the noes have it. Sarah Olney to move Amendment C to new clause 36 formally. Question is that Amendment C be made. As many of that opinion say aye.
Aye.
Contrary, no. No. Division.
Jack Abbott.
No.
Lois Atkinson.
No.
Juliet Campbell.
Aye.
Ambrose Charon Ambrose.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kent Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Oaker.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shaw.
Aye.
Dr Neil Shastri-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
Aye.
Ayes were 8 and the noes were 15. The noes have it. Does any member wish to move Amendment B to new clause 36? Not moved. Sarah Olney to move Amendment D to new clause 36 formally.
I'd beg to move, Chair.
The question is that Amendment D be made. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Division.
Jack Abbott.
No.
Lois Atkinson.
No.
Juliet Campbell.
Aye.
Ambrose Charon Ambrose.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. No. Surgeon Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Lebita.
No.
Kent Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts. Naz Shaw.
Aye.
Dr. Neil Shestry-Hurst.
No.
Sean Woodcock.
Aye.
The ayes were 8 and the noes were 14, so the noes have it. Sarah Olney to move Amendment E to new clause 36.
I beg to move, Chair.
Question is that Amendment E be made. As many of that opinion say aye?
Aye.
Contrary, no?
No.
Division.
Jack Abbott. Rose Atkinson.
No.
Juliet Campbell.
Aye.
Shambles Cheryl Lambert.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Surgeon Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Lebita.
No.
Kent Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts.
No.
Naz Shaw.
Aye.
Dr. Neil Shestry-Hurst.
No.
Dr. Maureen Tidball. Sean Woodcock.
Aye.
The ayes were 8 and the noes were 14. So the noes have it. The question is that the new clause unamended be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no?
No.
Division.
Jack Abbott.
Aye.
Rose Atkinson.
Aye.
Juliet Campbell.
No.
Shambles Cheryl Lambert.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins.
Aye.
Surgeon Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Lebita.
Aye.
Kent Malthouse.
Aye.
Sarah Olney.
No.
Dr. Simon Ofer.
Aye.
Rebecca Paul. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville-Roberts.
Aye.
Naz Shaw.
No.
Dr. Neil Shestry-Hurst.
Aye.
Sean Woodcock.
No. Checking where I was then. There's a vending machine downstairs. They didn't bother you though.
Yeah.
I did. About 6 hours ago.
Ayes were 14 and the noes were 8. So the ayes have it. New clause 37 has already been debated with Amendment 525. Kim Leadbeater to move formally.
Move formally, Chair. Voluntary Assisted Dying Services, Wales.
Question is that the new clause be read a second time. As many of that opinion say aye?
Aye.
Contrary, no? Ayes have it. The question is that new clause be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. New clause 38 has already been debated with Amendment 539. Kim Leadbeater to move formally.
Move formally, Chair. Information sharing.
The question is that the new clause be read a second time. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. New clause 39, debated with 539. Kim Leadbeater to move formally.
Move formally, Chair. Obligations of confidence, etc.
The question is that the new clause be read a second time. As many of that opinion say aye?
Aye.
Contrary, no? The ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye?
Aye.
The contrary, no? The ayes have it. New clause 40 has already been debated with clause 35 stand part. Kim Leadbeater to move formally.
Move formally, Chair. Reporting on implementation of Act.
The question is that the new clause be read a second time. As many of that opinion say aye. Aye. Contrary no. I think the ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye. Aye. Contrary no. I think the ayes have it. New clause 6 has already been debated with Amendment 276. Dr. Neil Shastri-Hurst, do you wish to move the new clause formally?
Withdraw, Chair.
Withdrawn. New clause by leave withdrawn. Right. We shall shortly come to new clause 9 in the name of Harriet Baldwin, which is going to be moved by Rebecca Paul, who will speak to it, and it won't be moved formally. So I'm now suspending for 15 minutes. We will return at... Okay, we'll return at 11 o'clock. 11 o'clock. Order. Right, we now resume debate. Rebecca Paul to move new clause 9.
Thank you, Chair.
One moment, clerk needs to read the title of the bill. No, she leaves it. Beg your pardon. It's my fault, not yours. Go on, carry on, yes. New clause 9.
Thank you, Chair. I rise to speak in favour of new clause 9, which seeks to make advertising of services by a coordinating doctor and or an independent doctor by a person in the course of a business an offence with a sentence of up to 2 years in prison or a fine or both. As we have spoken about previously, we will likely see private provision of assisted dying services if this bill is approved. Thus, this will create a potentially lucrative business opportunity for private businesses, particularly if provision on the NHS isn't consistent across the country or is overwhelmed. Advertising means the techniques used to bring attention to a product or service with the aim of presenting it as something a potential customer might need or want. The overarching aim of advertising by a business is to ultimately sell more of a product or service. We must keep that overarching reason in mind when considering this amendment. It would be incredibly inappropriate for such services to be advertised on billboards, public transport and even on daytime telly, targeting those who may be approaching the end of their lives. Ads run repeatedly along with those for stair lifts and life insurance. Such advertising could also undermine our national suicide prevention strategy by normalising suicide in certain situations. It becomes much harder to say to people that suicide isn't the answer if we are content to say that it is in certain situations. I can only imagine some of the difficult conversations generated off the back of an advert seen by a young girl or boy already battling with suicidal thoughts. How does a parent or guardian explain why suicide isn't right for them? And imagine the potential impact on men too. As we all know, suicide is a leading cause of death in men in this country. In 2022, for males between the age of 20 to 34, 1 in 4 deaths was categorised as intentional self-harm and event of undetermined intent. That is a shocking statistic. And that is why banning advertising of such services is so important.
Will my honourable friend give way?
I will, of course, give way.
I'm very grateful to my honourable friend who's making an impassioned argument, and I think most of us would agree billboards, television adverts would be egregious. But I note at subsection 3 it talks about electronic form. Now that could involve email correspondence between parties. How would that not be an advertisement in the terms of this amendment?
I thank my honourable friend for that intervention. So I think we would be talking about an advert via electronic form, so marketing a particular service. So I think we would have to go back to the meaning of advert for that. And obviously there are broader ways that advertising is done on social media and whatnot, which we would, I would also be seeking to prevent with this amendment. And so that is why banning advertising of such services is so important, so that a pro-suicide message isn't inadvertently delivered to millions of people who assisted dying is not appropriate for. We have to recognise there are vulnerable people out there that could be influenced by it. It is my view that conversations about assisted dying should happen in person between the relevant doctor and patient. They should not be prompted by a TV ad or something someone saw on a bus. And ads should not be coming up on someone's Facebook feed every time they log on. I hope committee members will support this common sense amendment, although I would note that I think it needs to go further and be expanded to cover clinics or other organisations advertising assisted dying services more broadly too, to be properly affected. But I would very much welcome the opportunity to work with ministers and the bill sponsor in terms of getting it right if the bill committee are predisposed to supporting this type of amendment. Thank you. Sorry, Naz.
Naz Shaw?
Yeah, sorry, yeah, Naz.
Okay, well, sorry, well, are you giving way, or are you...
I'll give way, yes.
Thank you, Honourable Member, for giving way. Would she also agree with me that actually by banning advertisement, it also mitigates the fact of advertising to young people, in addition to who she referenced with young people and suicide from a social media perspective, but also those girls who have eaten, well, young people who have eating disorders, or anybody who has eating disorders in particular, see this as an option so that they can qualify for it, because under this bill as it stands, they would qualify for it if they were termed as terminally ill due to their eating disorder.
I thank my honourable friend for that intervention, and I completely agree. So this is exactly what this amendment is trying to do. So we're trying to prevent advertising of an inappropriate service to inappropriate groups, and I think it makes sense, therefore, to effectively ban advertising accordingly. And I think most people would agree that it would be quite distasteful, inappropriate to have adverts for assisted dying everywhere people look. So I do hope people will consider supporting, even if it's in an amended form.
Advertising offences, services of coordinating independent doctors.
The question is that the new clause be read a second time. Lewis Atkinson.
Thank you, Chair. I have great sympathy with the intent behind this amendment, and I would like us to get to a position where it is workable. I think, I don't know whether the Honourable Lady would like to confirm that there is a similar offence in the Surrogacy Act of 1985 regarding making advertising of surrogacy arrangements an offence. I think the important difference in the Surrogacy Act is that there are further some caveats beyond those in this draft. For example, to ensure that there is not inadvertent creation of offences of the type that the Honourable Member there sets out. So, for example, the Surrogacy Act sets out that prosecutions that may result, as a result of that, would be carried out only with the approval of the Director of Public Prosecution, etc., to ensure that such safeguards were in place. I don't think it's, though I wait the Minister's comments, I don't think it's possible to support new clause 9 on the current basis for the reasons that the Honourable Gentleman lays out. I think in particular where we've set out, haven't we, that there will be a small, potentially a small number of doctors providing these services, and not for the general public, but for a GP, for example, would need to know where to direct their patient. And I cannot see how, other than having some form of electronic directory or email correspondence, it would be possible for such people to become available. But so I don't think that it's possible to vote for this at this stage. However, I'm going to put this on my notepad of things that I would be very keen to work with colleagues on at report stage, perhaps learning from the lessons of the surrogacy advice, taking advice from ministers, etc. I think we can all agree that there shouldn't be advertising, as you said, to the general public in terms of encouraging these services. Thank you, Chair.
Minister. Thank you, Chair, and thank you for giving me permission to remove my jacket. It's greatly appreciated. I would assume that other gentlemen in the room are also able to do the same should they wish to do so. New clause 9 would make it a criminal offence for a person to advertise their services as a coordinating doctor or an independent doctor under the bill. The offence applies to a person who, in the course of a business, publishes or causes publication of an advertisement for the services of acting as a coordinating doctor or an independent doctor under the bill, or who prints, devises or distributes an advertisement or causes this for the promotion of such services. The offence is wide-ranging and could include, for example, a person who unknowingly transmitted such advertising via electronic communications or social media. Should this amendment be passed, further work may be needed to determine how this would be enforced. I also note there is no provision for any defence in relation to these offences, for example, where a person responds to inquiries. Restrictions on advertising always need careful consideration and drafting, given the potential unintended consequences and potential ECHR impacts, in particular in relation to Article 10, freedom of speech. This is particularly so when breaches of the restrictions are made a criminal offence, as is the case here. However, Article 10 is a qualified right, meaning interference can be justified, provided it is in accordance with the law, pursuant of a legitimate aim, and necessary in a democratic society. So while this could engage Article 10, it may not violate it. Thank you, Chair.
Kim Ledley.
Thank you, Chair. New clause 9 specifically relates to the advertising of assisted dying services. And I fully understand the intent behind this provision, namely to prevent the unethical advertising of assisted dying services. And I wish to thank the Honourable Member for West Worcestershire for bringing this issue to the Committee's attention. However, on this clause specifically, as it's drafted, there are important nuances that need addressing to avoid criminalising individuals or organisations simply for providing information that is essential for those seeking access to these services. And I've looked into this issue because I think it is a really important point for the committee to consider. The Cancer Act 1939, Section 4, bans advertising for cancer treatments, which is a useful reference point. It prevents the advertising of any treatments, regardless of whether they are evidence-based or not. Similarly, as my colleague, the member for Sunderland Central, has mentioned, the Surrogacy Arrangements Act 1985 prohibits the advertising of surrogacy services. Both pieces of legislation are aimed at protecting individuals from misleading or unethical commercial activity. The situation with assisted dying is more complex, and the clause before us is not about advertising unregulated or unproven services. It actually talks about doctors who are offering a legal regulated service to those who meet the criteria. And as such, I have the same concerns as the Honourable Member for Solihull West and Shirley. In terms of considering Section 3 of the provision, which states that distributing an advertisement includes transmitting it in electronic form, participating in doing so and providing the means of transmission. This is particularly concerning because it could potentially criminalise doctors who are involved in the process of simply communicating with their patients, such as by sending an email, if they are seen as participating in the distribution of an advert. So the intent here is clear, and we must prevent the unethical advertising of assisted dying services. But we've got to ensure that this clause does not inadvertently hinder access to legal services by criminalising the actions of those doctors who are simply making themselves available in accordance with the law. We mustn't create barriers for those who need this service, nor should we penalise doctors for providing legitimate legal services. So I recognise the need to prevent the unethical advertising of assisted dying services, especially to avoid commercial exploitation or coercion. However, it's essential that we carefully calibrate this clause to ensure that it targets unethical advertising practices without sweeping in legitimate and necessary actions that help people find the care they need in a manner that is both lawful and respectful of their autonomy. As such, I'm very happy to work with colleagues, including the Honourable Member for Reigate and others, to look at how we can produce something to that effect ahead of report stage. Thank you.
Thank you, Chair. I'd just like to thank everyone for all of the very constructive points they've made on this debate, and I completely agree with the points you made. I think there is some work needed, but I'm really pleased that the bill sponsor and other bill committee members are willing to work with me and the tabling member to get this into a place where it does do what we want it to do and not capture things that we don't want it to capture, because I completely take your point around the concern about emails. That's not what we want to catch. I will, of course,
I was just going to make a suggestion. I think she's making a very good point. It's a constructive thing. It might be worth us having a look at Switzerland, where advertising is actually banned, but the provision of information is not. And it's a fine line that needs to be covered, but the Swiss seem to get the balance right.
I thank my honourable friend for that point, and I think he's absolutely right that we can learn from what other jurisdictions have done and leverage that and create an amendment, a new clause that works for what we're trying to achieve, and know that it's going to target the right advertising that we seek to target. But thank you.
Does the honourable lady wish to press the new clause for division?
Okay, I feel that for the spirit of it, I feel we should, and it doesn't prevent me putting it through a report, does it?
Fine.
So yes, I will.
New clause 9 as on the order paper. The question is that the new clause be read a second time. As many of that opinion say aye? Aye. Contrary, no? No. Division.
Jack Abbott. Lewis Atkinson.
No.
Juliette Campbell. Aye. Lambos Charalambos. No. Daniel Francis. Aye. Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. Aye. Sojourn Joseph. Aye. Stephen Kinnock. No. Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kip Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Sarah Sackman. Liz Saville-Roberts. Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
Thank you. The ayes were 9 and the noes were 14, so the noes have it. We now come to new clause 10, which has already been debated with Amendment 273. Sarah Olney to move formally.
I beg to move.
Collection of information on assistance.
The question is that the new clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kip Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman. Liz Saville-Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it. New clause 12, which has already been debated with Amendment 290. Daniel Francis to move formally.
Obligations related to training.
The question is that the new clause be read a second time. As many of that opinion say aye. Aye. The contrary, no. No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kip Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer. Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts. Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
Ayes were 8, the noes were 15, so the noes have it. We now come to new clause 18 in the name of Liz Saville-Roberts. To move new clause 18, please. To move formally.
Oh, no, I don't mean not to say that. No, I don't think I did mean to say that. I would like to speak to it, and I'm just getting carried on with my... I'll admit my errors. It's always wiser to admit your errors than have somebody else tell you.
Liz Saville-Roberts.
New clause 18, and we have received additional evidence from the Welsh Language Commissioner, which comes to bear on this new clause quite considerably, and it arises, the Welsh Language Commissioner's comments come from amendments we previously discussed, 413, 427, 428, and Amendment A to new Schedule 2. So I think it is worth having them on record, or an interpretation of them, because the safeguarding process is a matter of both Welsh language legal rights and a clear communicative necessity. And one of the quotes from the Welsh Language Commissioner is that it is essential that Welsh speakers can discuss the decision to end their own life through the medium of Welsh if they so wish. And the key word here is discuss. We are very used to Wales to the convention of documentation and information being available in bilingual forms. But what I have endeavoured to do with the amendments that I have brought forward in relation to the Welsh language previously is to make sure that those people who are involved with the process are, to the degree that all reasonable steps have been taken, able to converse with fluent proficiency in the preferred language of the person who comes before them, seeking their support and seeking also their judgment, if you like, in relation to capacity and coercion. Now, it seems to me that all reasonable steps, therefore, should be taken to ensure that the key human aspect of this discussion, the conversations between the person and the coordinating doctor, the independent doctor, and the panel, should be conducted in Welsh when that is the preferred language. And that the Welsh speakers should not have to request these means of communications, the means or the ability to use Welsh, they should not have to request that each time the process moves from one person to another. That this should be recognised at the beginning of the process, and again, all reasonable steps being taken then, that the people are able to communicate in the language with which they are most naturally comfortable, the language which comes to them when they are expressing perhaps their deepest fears and their greatest emotions. There will, of course, on occasions, it will be, I know, difficult to find people within a reasonable time span, and we will need to train people in certain roles. But that is where the all reasonable steps phrase, if you like, requirement comes in. Now, the Commissioner notes, and this is why it's important for me to take, forgive me that it is so late, to take a little time, that the Commission notes there's already been some discussion in committee whether provisions are necessary on the face of the bill. And that is why I want to refer to what the Welsh Language Commissioner says. Now, the Welsh Language Standards number 7 Regulations 2018 are the relevant standards which apply to health boards and NHS trusts in Wales. Although the standards place duties to provide a range of services through the medium of Welsh, such as correspondence, case conferences, documents and forms, they do not go so far as to place duties on health boards to ensure that Welsh speakers can receive clinical services through the medium of Welsh. Now that, I would propose, is why we need this on the face of the bill. Legislation as it stands, being relevant to Wales, is not sufficient to even give us the reasonable steps provision. Whilst Welsh language standards apply to NHS primary care services in Wales that are contracted by health boards, Welsh language standards currently do not apply to independent providers. However, a limited number of Welsh language duties have been placed on independent primary care providers. Of course, this is your GPs. As is the case with respect to the Welsh language standards, these duties do not go so far as ensuring that Welsh speakers can receive clinical primary care services through the medium of Welsh. That, again, is why the all reasonable steps is doing the best that we can to make sure that people are able to communicate in the language which comes most natural to them. So it's important to note that the standards set out duties relating to health services in general, while the bill in question relates to a much more specific and specialised service. It also relates to a highly sensitive issue where being able to provide in an individual's first language is essential. The key point here, says the Commissioner, is that stronger provisions could be made in an area such as assisted dying compared to that which would be practically possible in standards relating to health services more general. As such, if there is an opportunity, she says, to make specific provisions in legislation regarding ensuring clinical services through the medium of Welsh, then it should be done. Now, I know that there are two concerns. I mentioned already the phrase, all reasonable steps. Now, I really want to I want us to have a decision in this place here and now, and I want to hear back from the sponsor and from ministers that there is an appreciation that we need something on the face of the bill. Because as you know, the 1993 Act, which applies to the judiciary, only gives the individual the right to speak Welsh. It doesn't give them the right to discuss, to be understood. And I hope that what I've been able to do with this evidence also is that the Welsh language standards in Wales do not go as far as I think we need to go with this legislation. The other point here, and again this is part of the nature of us finding our way with amendments, is my understanding of the extent, the geographic extent of this amendment is to the geographic area of Wales only, that it would not apply in England, as is normal with other legislation of this respect. But I really want to hear a response from the sponsor and from the ministers before I decide whether to push this to a vote. But I do feel that on this final day that we need to have something on record that says that we respect the use of the Welsh language, and we will do our best to make sure that amendments act effectively in that respect.
Provision of information in English and Welsh.
Question is that the new clause be read a second time. Minister?
Thank you. Thank you, Sir Roger. This group relates to new clause 18, which would ensure that anyone seeking assistance under this bill in England or Wales receives any services, reports, declarations or certificates of eligibility in Welsh, if that is their first or preferred language. Amendment New Clause 18 is linked to the amendments tabled by the sponsor that the form and content of any statement or declaration be set out in regulations rather than in the schedules to the bill. The amendment requires that any regulations made specifying the form and content of declarations or statements required in relation to the first declaration, the coordinating and independent doctor's assessment, the second declaration and the final statement must make provision for these to be provided in both English and Welsh. A legal requirement that all services, as well as reports, declarations or certificates of eligibility, must be provided in Welsh, where an individual's first or preferred language is Welsh. This would go beyond usual practice in England. Such a requirement may lead to operational issues such as a reduced pool of registered medical practitioners or assisted dying panel members who are able to carry out the functions under this bill. I'd like to put on record again the government's continued commitment to devolution and to working with devolved governments. The government has taken a neutral position on this bill and on the matter of assisted dying, but is committed to working together with the Welsh Government to resolve any legal and technical issues and discuss constitutional matters that might arise. Thank you, Chair.
Thank you, Chair. And I thank the Honourable Member for tabling the new clause. And she's made extremely valuable points, as she has done throughout committee proceedings, with regard to the importance of respect for the Welsh language, and I think she's absolutely right. There are some issues, as the Minister has said, in terms of the drafting of the bill as to what the implications would be, not just in Wales but also in England. But I think as such, I'm very happy to, as part of my conversations with ministers within the Senedd, to discuss these issues. And it's my understanding that they are happy to meet following the proceedings of the committee, and this is certainly something I think we should discuss with them. And it's very important that her thoughts have been put on record, and I think ahead of report stage we need to look at what can be on the face of the bill to reassure the concerns that she's got.
Can I say a few words? I honestly feel that the point that the legislation that as it stands in relation to the Welsh Language Act of 1993 and the standards of 2011 and 2018 in health are not sufficient for what we are endeavouring to do here. And that right for people to use their language, their first language. It is of some regret to me that the only two languages that are protected by law and under England and Wales are Welsh and English, and I would be happy if there were more. But these are the only two languages that I can discuss, and Welsh obviously is very close to my heart. I do feel on this last day that it is an obligation to push this to a vote, because I do feel otherwise that we will default into legislation that is not sufficient for what we're endeavouring to do here. So, with those words.
Question is that the new clause be read a second time. As many of that opinion say aye.
Aye.
Contrary, no. No. Division.
Jack Abbott.
Aye.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bamble Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer. Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts.
Aye.
Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 12 and the noes were 11. So the ayes have it. The question is that new clause be added to the bill. As many of that opinion say aye. Aye. Contrary, no. No. The ayes have it. We now come to new clause 20, which has already been debated with new clause 35 stand part. Does anybody wish to move new clause 20 formally? Not moved. New clause 22 has already been debated with amendment 480. Danny Kruger, do you wish to move formally?
I'd like to move.
No obligation for occupiers or operators of premises.
The question is that the new clause be read a second time. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
No.
Bambos Lambos.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer. Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman. Liz Saville-Roberts.
No.
Naz Shah.
No.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
No.
Normal service has been reviewed. The ayes were 3 and the noes were 20. So the noes have it. New clause 23 has already been debated with new clause with amendment 480. Rebecca Paul, do you wish to move forward?
I beg to move.
No detriment for care home or hospice not providing assistance.
The question is that the new clause be read a second time. As many of that opinion say aye.
Aye.
Contrary, no.
No.
Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
No.
Bamble Lambos.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer. Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts.
No.
Naz Shah.
No.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
No.
The ayes were 3 and the noes were 20. So the noes have it. Clause 23 has already been debated with 517. New clause 23. What? 25, I beg your pardon. I can't read. I've got it in front of me. I can't read it. We now come to new clause 25, which has already been debated with 517. Dr. Tidball, do you wish to move formally?
I move formally.
Independent advocate.
The question is that the new clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye. Aye. Contrary, no. The ayes have it. New clause 28, which has already been debated with clause 35, stand part. Mr. Francis, do you wish to move formally?
I beg to move, Chair.
12-month assessment of the Act.
The question is that the new clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Lambos Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. No. Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Orney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Seville Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
Aye.
Ayes were 8 and the noes were 15, so the noes have it. We now come to new clause 30 in the name of Jack Abbott. Jack Abbott to move new clause 30, please.
I'm very grateful, Chair. Thank you very much. And I'm not planning to speak too long, and I'm minded at this stage not to move this to a vote, but just a few brief remarks. Clearly, it is what it says on the tin here in terms of, sorry, excuse me. It does what it says on the tin here in terms of this amendment. In the rare, and I do underline the word rare, cases where two family members, in particular couples, both receive a terminal diagnosis in relatively short space of each other and would therefore qualify under this Act if passed. Now, for very, very many people and couples, there would be absolutely nothing untoward about all of this, and I'm sure many people would make a decision in their kind of best interest, particularly if they've been married or partners or whatever it might be for a specific period of time. This amendment would insert a new clause stipulating that if any medical or healthcare professional receives an indication that a patient is seeking assistance at the same time of one of their family members, including and especially partners, both a coordinating doctor and a registered medical practitioner from the person's GP practice must be notified, and that the patient must be referred for both a psychiatric assessment and an assessment by a social worker. The assessing doctor would then have to take into account any opinion provided by that psychiatrist or social worker and share with the assessing doctor. In my personal opinion, and why I'm probably not moving to this vote, is that I can appreciate conversations that this may be a little bit too prescriptive at this stage, but I think it's something that I would want to be considered at the report stage and under further deliberations by the government if this, as I say, bill is to be passed and it goes into the implementation phase. But I think everyone in this committee can appreciate why this sort of scenario, as rare as it may be, would need to be considered for some of the conversations we've had, for the reasons we've had conversations around today, around coercion or other sort of abuse, obvious or more pernicious. We do know that in certain situations there will be people, particularly in a married or a long-term partnership, where there may be these sorts of aspects at play. As I said, I'm sure the vast majority of cases, and as rare as they are, would be under that scenario. But as I say, I do hope that these things are considered and that greater scrutiny is probably needed in this sort of area under these sorts of scenarios. And essentially, this would allow for a more comprehensive and thorough assessment of the person's well-being and social context, including their relationship. So I'll leave it there. As I said, I wasn't intending to speak too long.
and I'm not minding to move it to a vote at this stage. Thank you.
Relatives seeking assistance at the same time.
The question is that the new clause be read a second time. Minister.
Thank you, Sir Roger. New clause 30 would introduce a duty on medical or other healthcare professionals involved in the person's care, including on assessing doctors, should they receive an indication that a person is seeking assistance to end their own life contemporaneously with one of their family members. The duty has two parts. First, the medical or other healthcare professional who receives this indication must notify the person's coordinating doctor and a registered medical practitioner from the person's GP practice. Second, if an assessing doctor receives notification of that fact, they must refer the person for assessment by a registered medical practitioner specialising in psychiatry and a registered social worker and take account of their opinion. The assessing doctor must also share that opinion with the other assessing doctor. In the absence of definitions, issues could arise as to who is covered by the term family member and the meaning of contemporaneously. The additional referrals will add to the length of the application process. Thank you, Sir Roger.
Jim Levitt.
Thank you, Chair, and I thank the Honourable Member for bringing the new clause forward. I do have some concerns around the broad definition around family member and what that would mean. And I also feel that it would be potentially excessive if there was this coincidental situation where two members of the same family were tragically in the same situation, have been terminally ill, and the extra burden it would place on them to go through an even more rigorous process when they would both be assessed through the thorough regime of the bill, including going to the multidisciplinary panel. But I think it's a point worth discussing, and I welcome the fact that he's raised it.
Jack Abbott. Thank you, Chair, and I appreciate both the points made by the Government Minister and the sponsor of the bill. I think it's fair to say, I think family member, although it's a relatively non-specific description, I think it's quite clear about the thrust of where I was trying to go with this amendment, and clearly I think this is particularly directed at couples. And I understand fully the point the sponsor of the bill makes in terms of not wanting to go through a huge number of extra layers. I've spoken at length a number of times in this committee about not wanting people going through this really awful period at the end of their life, sitting in endless meetings or assessments or courtrooms. I think the point I would just add to, I know I've already made, is that this would be a relatively exceptional circumstance. We do know that there will be situations where potentially coercion and other sorts of pressures are at play. And so, while I agree it may be an incredibly rare scenario, and two people may just want to go through the later stages at their own life towards the end of life together, I do think this would represent a place where extra checks would potentially need to happen at some point, just to absolutely ensure that there is nothing untoward there and there isn't other sorts of pressures or coercion at play, as rare as it is. So, as I say, I won't be pushing it to a vote, Chair, but I appreciate being able to have the chance to raise these points tonight. Thank you.
Is it your pleasure that the new clause be withdrawn?
Aye.
New clause by leave withdrawn. New clause 32 in the name of Danny Kruger. To move new clause 32, please.
I'm going to withdraw the new clause.
New clause 32 withdrawn. New clause 33, which has already been debated with Amendment 450. Sarah Olney to move formally.
I'd like to move.
Collection of statistics, number 2.
Question is that the new clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Jack Abbott.
Yeah. Aye, sorry.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sir John Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kip Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shaw.
Aye.
Dr Neil Shastry-Hurst?
No.
Dr Marie Tidball?
No.
Sean Woodcock?
Aye.
The ayes were 9 and the noes were 14, so the noes have it. New clause 34, Danny Kruger to move.
Like to move?
Assisted... Oh.
You're going to speak.
Sorry.
I'll speak to it.
Sorry.
Thank you. I'm going to speak to a very important principle as expressed in new clause 34, but Sir Roger, I think this is going to be my last speech in the committee. So I wanted to... Wait for it. I wanted to take the opportunity to thank you, Mr Chairman, and all your colleagues who've chaired the and also the clerks, particularly, who've done such amazing work behind the scenes. It's a huge amount of work to them. And also my thanks and respect to all members, particularly the Honourable Lady, for her good faith and good nature all through this process. And I've got great respect for all members, particularly hero is, of course, the member for Enfield and Wood Green, who's the hero of every day, and the most popular speaker every day. We're looking forward to his final speech. And can I just quickly pay tribute to all the other members from not in the committee who've contributed to our debates by tabling amendments, and I really am encouraged by many of those, and I just personally pay tribute to the member for York Central, who's been a very powerful influence on me, and I think has attempted to do very good work with this committee. And also the member for Ronnie Mead and Weybridge, who is perhaps in sympathy with the honourable member, the most liberal member of the committee, has attempted to create an assisted dying bill that I think does justice, actually, to the real principles behind it, the principles of autonomy. And I want to just acknowledge that it's on the member for Ronnie Mead's conception of the bill that I want to quickly speak today and reflects the amendment that I've tabled, because his amendments would have taken assisted dying out of the NHS, indeed out of healthcare altogether, and I think he was right to try and do that. If we are going to do this thing, then I think we should recognise that it is not healthcare that we are proposing to legalise, and indeed new clause 36 does recognise that there is an essential incompatibility between the service that is proposed here and healthcare as it is traditionally understood in our country and indeed enshrined in the NHS Act. And more than that, Mr Chairman, the foundations of healthcare in the West, I think, are contravened by this bill. The Hippocratic Oath contains the promise, neither will I administer a poison to anybody when asked to do so, nor will I suggest such a course. That's the oath that doctors take, and this has been the official ethical basis of medical practice in the West for millennia. But the current bill involves the final official abandonment of this ethical tradition, and I would implore the committee to reflect on the essential principle that healthcare is the antidote to sickness, whereas what we are proposing here with assisted suicide is the antidote to life. That is the treatment that it is proposed that we legalise. It is entirely different from healthcare in principle and in practice. And it is therefore no surprise that so many of the professional bodies who are involved in healthcare regard this proposed treatment as incompatible with their professions. So the BMA agrees that it should be a separate service. And I was struck by an article that appeared last November in the BMJ, the British Medical Journal, called Reframing Assisted Dying Through the Civil Law, by a group of palliative care professionals who, Possibilities and Challenges for the UK, it's called. This sets out how, if assisted dying is to be legalised in this country, how it might best be organised and delivered. And the clause that I've tabled, and all that flows from it, would enable us to design a better assisted suicide service than the one that this bill gives us. And the Honourable Lady this morning, and I think the Honourable Member this afternoon, asked how it should be done if we were going to do it. and my honourable friend, Member for Reigate, gave some suggestions, and I want to build on what she said and say how I think this bill should have been framed, and indeed how I and others have tried to ensure that it is framed through the amendments that we have tabled. What we have done is to try to match the bill with the campaign. The campaign for assisted suicide and what the campaign asked for, and I think what there's understandably considerable public support for, is the right of people suffering at risk of suffering a terrible, agonising death at the very end of their life, people whom palliative care cannot help, to end their lives a few days or weeks early. And we can argue about how many people that is. I think the number that palliative care could not help if we organised our palliative care system properly is infinitesimally small. It's almost non-existent. But we disagree with that. So let's just assume that there are some people who would fall into that category. The campaign for this bill is the campaign for those people to have a right to have an assisted death. But that is not what we've got in this bill. What we've got is a right for anybody who, in the opinion of 2 doctors, might reasonably be expected to die within 6 months, to request and receive lethal drugs, all paid for and assisted by the NHS. That's not what the campaign has been for. So let me suggest how, if we were being honest to the campaign, we would design this thing, not as healthcare, but as a compassionate suicide service for people facing physical agony at the very end of their life. Eligibility would be, as we tried to ensure it was at the beginning of our deliberations, it would be for people fearing pain, not feeling a burden, with a proper capacity test, not the Mental Capacity Act test, with proper, meaningful safeguards against coercion. We would have doctors and a multidisciplinary team at the right stage of the process, right at the beginning, at the first assessment. We'd have all the appropriate signposting and the provision of palliative care as an alternative to assisted suicide. And then we'd have a proper judicial process to decide whether to approve the application. And then as for provision, from assessment through to the final act, it should not be in the NHS. It should not be provided by any profit-making providers, advertising their services and receiving money for every death that they assist, which is what we've probably got with this bill. It should be provided by non-profit organisations, tightly regulated, funded not through NHS commissioning or by the patients, but by philanthropy. And what the scale of this is all to be discovered, I guess, if we pursue this bill. It's been suggested the lower end of the expectation would be around 6,000 deaths per year. On the calculations that have been made in this paper by these experts, that would be around £10 million a year budget to manage that 6,000 person caseload. £10 million is in the ballpark of what the campaign groups promoting this bill have been spending. I think there would be no difficulty raising that sort of money if it's what people want. After all, hospices have to raise millions of pounds every year to fund their work, and I don't see why assisted dying services shouldn't be able and required to do the same thing. So I think there is a way to have done this more consistently with the campaign for assisted suicide. To be clear, for avoidance of doubt, I would oppose that too, because I think that even that much more honest, much more tightly circumscribed service would profoundly alter our society. It would send a signal that some people are better off dead, and I think it would be the wrong thing to do for us as a country. But at least it would be honest. It would be consistent with the campaign. And I end to Roger with the observation that what I've just described is what I think the public think we are doing here in this committee, designing a service like that for that small number of people at the very end of their life facing terrible physical deaths. It's not what we've done. It's not what this committee has approved. It's not what the original bill said, and it's not what the bill is now as we send it back to the House of Commons. So I hope that the public and our colleagues in Parliament will recognise that this bill is not the one they thought they were getting. Thank you.
Assisted dying, not a medical treatment.
The question is that the new clause be read a second time. Rebecca Bull.
Thank you, Chair. I rise to support new clause 34, which clarifies that assisted dying isn't a medical treatment, not only because of the principle behind it, which I've talked about a lot already, but because of the unintended results. We need to recognise that much law, rules and regulations have been written using the word treatment, but never envisaged assisted dying being included within that. Every bit of law referring to when a treatment can be given with or even without consent, like under Section 63 of the Mental Health Act, becomes a potential problem if assisted dying is technically viewed as a medical treatment. New Clause 34 is therefore essential to protect the meaning and integrity of current law in this area and to protect patients going forwards. In written evidence, Professor David Jones points out that there are dangerous consequences to classifying death as a medical treatment. As a general principle, he observes, and I quote, if an effective medical treatment cannot be self-administered orally, then other routes should be considered, including those administered by a healthcare professional. So here you can immediately see the problem if assisted dying is a treatment. The view that such a treatment can be administered by a healthcare professional suddenly moves us into euthanasia territory, which is clearly not the intention of this bill. He goes on to say, if a treatment effectively reduces distressing symptoms in one category of patient, adults at the end of life, then it should be considered for treating other categories of patient. So again, if you substitute the word treatment for assisted dying, you get a wholly unacceptable approach that could open the way to offering assisted dying to under 18s, as in Belgium, or to people whose psychological suffering is unbearable, as we've seen in Belgium and the Netherlands, with the euthanasia of people with mental health conditions. And finally, he says, where a patient does not have capacity to consent to medical treatment, then doctors should provide whatever treatment is of overall benefit to the patient. I mean, I think, again, if you substitute the word, you can see that that gives us a big issue. Of course, the bill as it stands has a capacity requirement and an age requirement and a physical illness requirement and a requirement for self-administration. But the point is that by classifying assisted dying as a medical treatment, we are making these requirements less stable and introducing the potential for conflict within existing law. We are inviting future parliaments to question why they are there in the first place. Why arbitrarily restrict this medical treatment when we don't restrict other treatments in the same way? If we don't rule out assisted dying as a medical treatment, we are potentially opening this bill up for challenge by the courts when assisted dying treatment is limited to certain routes. That is one reason why the Association for Palliative Medicine has explicitly backed the principle which is represented by my honourable friend's amendment. It says in written evidence that defining death as treatment would be contrary to all prior medical practice and public expectation and laden with risks of unintended consequences. This bill may look set in stone now, but the law can easily be amended in future, for instance by amending a major health bill. What we decide here could have major consequences in a few years, and I would therefore urge that we future-proof this bill now by explicitly declaring on the face of the bill that assisted dying is not a medical treatment. Then all of those issues I've just set out will not be an issue at any point. Thank you.
Thank you very much, Sir Roger, and I'd like to associate myself with the comments of the Honourable Gentleman for East Wiltshire about the amazing work of the staff and clerks and everybody. Thank you very much to everybody. New Clause 34 seeks to prevent assisted dying under this bill from being considered a medical treatment. As drafted, the bill is silent on the question of whether or not the provision of assistance under this bill can be considered a treatment. If accepted, this amendment may be interpreted to mean that the term medical treatment in any other piece of legislation may not be interpreted so as to include assisted dying. The term medical treatment is used in many different contexts across the statute book and has different meanings according to the particular context. This clause is therefore likely to produce unpredictable and potentially unintended effects. Thank you, Sir Roger.
Thank you, Sir Roger. We're sort of entering deeply philosophical territory, which is welcome and has happened several times during the committee's proceedings. I think the Honourable Member, as ever, raises some interesting points, but for me this isn't something that would go on the face of the bill. I think we all have our views as to how we frame assisted dying and choice at the end of life, but I don't think defining, or rather not defining, assisted dying in this way is something which would be applicable to go on the face of the bill. So I won't be supporting the amendment.
Based the Honourable Lady's, the Honourable Lady is entitled to speak if she chooses to do so, but I think the Honourable Lady sat down. Danny Crew.
I'm going to push it to a vote. Sir Roger.
New clause 34, as on the order paper. The question is that the new clause be read a second time. As many of that opinion say aye.
Aye.
Contrary, no?
No.
Division.
Jack Abbott.
No.
Lois Atkinson.
No.
Juliet Campbell.
No.
Bambles Sharon Ambles.
No.
Daniel Francis. Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. No. Sir John Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
No.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts. No. Naz Shah.
No.
Dr Neil Shastry-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
No.
The ayes were 2 and the noes were 21, so the noes have it. We now come to new clause 35 in the name of Dr Marie Tidball. Dr Tidball to move new clause 35.
Thank you, Sir Roger. It's a pleasure to serve under your chairship. I rise to speak to new clause 35, the final new clause of this committee. As I said in my speech for new clause 25 and associated amendment last week, I wanted to strengthen the voice of disabled people in this bill. This new clause would require the Voluntary Assisted Dying Commissioner to establish a Disability Advisory Board which would report annually on the implementation and impact of the bill, if it were to pass through Parliament, on disabled people. This has been designed to ensure that disabled people have a voice at the heart of this bill and an ongoing role in monitoring its impact. The Disability Advisory Board model reflects a structure which was used at the Department of Health to implement the Autism Act 2009 and monitor the implementation of its provisions, statutory guidance and strategy. This was a highly effective body. Putting my amendment for a Disability Advisory Board structure on the face of the bill entrenches it in the work of the Commission to enable a long-term and iterative structure where disabled people can report on the reality of the impact of this bill on disabled people across this country. This reflects the comments made by Dan Scorer of MENCAP in oral evidence, who said if the bill was passed, we would want to see strong representation from patient groups as well as from people who have been involved in the process, such as family members, advocates and clinicians, to make sure that if serious issues are being raised, they can be picked up early and addressed. As such, this board must consist of people who have a disability under the Equality Act 2010, representatives from disabled people's organisations and other such persons or organisations as the Commissioner considers relevant to the impact of the Act on disabled people. Under my amendment, the Commissioner must, within 6 months of themselves being appointed, appoint a programme board to advise on the implementation of this bill and annually thereafter report on the impact of the bill's operation on disabled people. This amendment reflects the learning of Dr Greg Mewett, specialist palliative care physician from Australia, who gave oral witness evidence to this committee about their implementation task force, which includes a strong disability advocate. My new clause goes further than this instrument and includes a rigorous reporting process which not only requires the advisory board to report to the Secretary of State and the Commissioner within 6 months of the Commissioner being appointed and annually thereafter, but that the Secretary of State must, within 3 months of receipt of any report under subsection 3 of this new clause, lay that report before both Houses of Parliament. During the evidence session, I asked witnesses for their views on what structures or mechanisms they thought could work to facilitate the opportunity to hear the voices of disabled people in monitoring the implementation and impact of this bill if it were to pass through Parliament. Dr. Myro Griffiths said, "I think there needs to be further robust action around how to collect data and allow it to be analysed to see the trends that are occurring and why people are pursuing this option and how that may play into broader political and socio-economic issues such as the lack of services elsewhere or frustrations for disabled people and their families in trying to access particular services." Dr. Griffiths continued and said, "I would, therefore, encourage their representation on any form of advisory council. I would also request that disability studies scholars, who are often left out of the discourse around disability policy, are part of any form of mechanism to advise or scrutinise." Subsections 2b and c in my new clause provide for this. Professor Tom Shakespeare, in oral evidence, also corroborated the benefits of such an advisory board. "I think this is a very good idea," he said. Importantly, Fazile Hadi from Disability Rights UK stated, "Should this bill go through, it would be good to see a monitoring mechanism. I cannot say what that should be, but it would be good to see disabled people shape it. Some 45% of older people are disabled, so disabled people are going to be very affected by the bill." Poignantly, she went on, "It is often our experience that we are the last people who are spoken to. Maybe that is what is behind the question. We should of course be at the table now in respect of whatever mechanisms and in the shaping of any implementation should the bill be passed. There is, and there should be, nothing about us without us. As a disabled Member of Parliament myself, I am grateful for the Honourable Member for Spen Valley for inviting me to sit on this committee. I have worked hard to put together a structure with this amendment alongside my earlier new clause 25, which makes sure that disabled people are firmly at the table in the process of monitoring the implementation and impact of this bill, and I urge members of this committee to support this new clause 35.
Disability Advisory Board on the implementation and implications of the Act for Disabled People.
Question is that the new clause be read a second time. Jack Abbott.
Very good. in a moment. Very good. Thank you, Chair. I just at this point want to pay tribute to my honourable friends from Penistone and Stockbridge, but also Bexley Heath and Crayford. They've consistently put forward really important amendments that are very close to my heart and improving an area of the bill, I think, as it's improved measurably. The reason I'm just briefly speaking in favour of this amendment, we've had a number of good amendments that have said about making sure we've got proper representation for vulnerable people during the process. We've also had a lot of discussion about the very, very important need to be regularly monitoring and reporting back on areas of this bill. In my opinion, though, this particular amendment brings, or this new clause rather, brings all of this together, making sure we've got real oversight, but also a real thrust and a point to it as well. It's, in my opinion, not just good enough just to report back some statistics, it's what we do with them. And having this sort of panel with expertise and life experience on it as well, I think is a really significant step forward for people with disabilities, learning needs and everything else that it might be included in this. So once again, I pay tribute to my honourable friends for this work, and I'll be fully supportive of this news clause this evening. Thank you.
Minister.
Thank you, and I can be, again, I hope, very short, given the witching hour. This amendment tabled by the member for Penistone and Stocksbridge would require, as we've heard, the Voluntary Assisted Dying Commissioner within 6 months of their appointment to establish a Disability Advisory Board. The Advisory Board must include representation from disabled people and disabled organisations. And within 6 months of its appointment, the Advisory Board must report to the Secretary of State and the Commissioner to advise on the implementation of this Act for disabled people. We anticipate the Advisory Board's annual report will be separate to that of the Commissioners, and that in time this may be subject to a level of integration between the two bodies. Practical arrangements for the advisory board would require further consideration, but the government can see no workability reason why this shouldn't go ahead.
Dr. Tibb, do you wish to press the measure to a vote?
Yes,
I beg your pardon, Kim Ledbeater. Sorry, Kim.
Sorry, thank you, Chair. I'll just associate myself with the comments that others have made, particularly the member for Ipswich, around the fantastic work that my honourable friend, the member for Penistone and Stockbridge, has done with regard to this new clause, but also other amendments, and indeed the member for Bexleyheath and Crayford. And if I can associate myself with the comments of the Minister and of the member for East Wiltshire around the fantastic work that our chairs have done through this committee, the clerks of the House, and indeed all the staff of the House, and pay tribute to colleagues who have served on this committee. It has been hard work, and if I reflect on the sometimes sadly very personal criticism that was directed at me when we were putting the committee together, people said that it would just be people who all agreed. And it would be people who would rush it through. And here we are at this hour. I don't think this has been rushed through. I think we've taken an extremely thorough approach. No amendments would be made, was the charge. We've made lots of amendments, and we will put this bill back to the House in an even stronger position than it was at second reading. And I pay tribute to everybody involved in that process. Thank you, Chair.
Dr. Tibb.
Third time lucky, I beg to
The question is that the new clause be read a second time. As many of that opinion say aye? Aye. Contrary, no? I think the ayes have it. The question is that the new clause be added to the bill. As many of that opinion say aye? Aye. Contrary, no? The ayes have it. We now come to the question that Schedule 1 be the first schedule of the bill, with which it would be convenient to take Schedules 2 to 6. All amendments to the schedules have fallen. I'll just take a sounding. Is there any member, I don't wish to curtail debate at all, is there any member who wishes to speak specifically on any of the schedules? Is there any member present who wishes to vote against individually any of the schedules? What? They need to disagree. No. I was going to try and make life easy. I failed. I understand that you have to take some of the schedules out, which I was unaware of. So we'll take them one by one. We come to, nobody wishes to speak against them. So the question is that Schedule 1 be the first schedule to the bill. As many of that opinion say aye. Aye. Contrary, no. Let's try that again. We're in slightly uncharted waters. Apparently you're getting rid of them. Order. We'll get there. We'll take the Dr. Tibble line. If we try often enough, we'll get the right result. So, the question is that Schedule 1 be the first schedule of the bill. As many of that opinion say aye. The contrary, no. No. The noes have it. The question is that Schedule 2 be the second schedule to the bill. As many of that opinion say aye. The contrary, no. No. The noes have it. The question is that Schedule 3 be the third schedule to the bill. As many of that opinion say aye. Contrary, no. No. Ayes. The noes have it. The question is that Schedule 5 be the... There's 4 gone. 4, 5. The question is that Schedule 5 be the fifth schedule of the bill. As many of that opinion say aye. Contrary, no. No. The noes have it. The question is that Schedule 6 be the sixth schedule to the bill. As many of that opinion say aye. Contrary, no. No. The noes have it. Expensive with that lot. We now come to new Schedule 1, which has already been debated with Clause 12 stand part. Kim Leadbeater to move formally.
Move formally, Chair.
The Voluntary Assisted Dying Commissioner.
The question is that the new schedule be read a second time. As many of that opinion say aye. Aye. Contrary, no. No. Division.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell. Bambos Charalambos.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green. Rachel Hopkins. Sojourn Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
No.
Dr Simon Ofer.
Aye.
Rebecca Paul. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts. Naz Shah.
No.
Dr Neil Shastri Hurst.
Aye.
Dr Marie Tidball.
Aye.
Sean Woodcock.
No.
The ayes were 15 and the noes were 8, so the ayes have it. We now come to new schedule 2, already debated with clause 12 stand part. Kim Leadbeater to move formally. Beg your pardon, I've missed something. What have I missed? What we've done that? Oh, beg your pardon. So sorry. Question is that the new schedule be the first schedule to the bill. As many of that opinion say aye? Aye. Contrary, no? No. I think the ayes have it. I think we're on safe ground there. Right, let's try again. It really is the Dr. Tidball approach, isn't it? We now come to new schedule 2, which has already been debated with clause 12 stand part. Kim Leadbeater to move formally.
Move formally, Chair.
Assisted dying review panels.
Question is that the new schedule be read a second time. As many of that opinion say aye? Aye. Contrary, no? No. Division.
Jack Abbott.
Aye.
Lewis Atkinson.
Aye.
Juliet Campbell. No. Bambos Charalambos.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green.
Aye.
Rachel Hopkins.
Aye.
Sojourn Joseph.
Aye.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
No.
Dr Simon Ofer.
Aye.
Rebecca Paul.
No.
Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts. Naz Shah.
No.
Dr Neil Shastri Hurst.
Aye.
Dr Marie Tidball.
Aye.
Sean Woodcock.
No.
The ayes were 16 and the noes were 7, so the ayes have it. Liz Saville Roberts to move Amendment A to new Schedule 2, please.
In light of the new clause 18 decision, I think I will withdraw this because we can discuss in further detail some of the terminology.
The question is that the amendment be withdrawn. As many of them? Fine. Thank you. Does anybody wish to move Amendment C formally? Yes? The question is that Amendment C be made. As many of that opinion say aye? Aye. Contrary, no? The ayes have it. Does anybody wish to move Amendment B formally?
Again, I will, Chair.
Question is that Amendment B be made. As many of that opinion say aye?
Aye.
Contrary, no?
No.
Division.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger. Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards. Sarah Sackman.
No.
Liz Saville Roberts. Naz Shah. Aye. Dr Neil Shastri-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8 and the noes were 15, so the noes have it. The question is that the new schedule, as amended, be the second schedule to the bill.
Point of order, Chair.
Not during a division. The question is that the new schedule, as amended, be the second schedule to the bill. As many of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. Is there something that says that should be added to the bill? The question is that the new schedule be added to the bill. As many of that opinion say aye.
Aye.
Contrary, no. The ayes have it. Point of order.
Sorry, Chair. Can I just inquire what happened to new schedule 2D, the amendment 2D? I don't think we divided on that. Oh, it's not selected.
It wasn't. No.
Okay, so apologies, Chair.
Right. Moving swiftly on, new schedule 3. We now come to new schedule 3, which has already been debated with amendment 450. Sarah Olney to move formally.
Can I speak advice, Chair? I thought this was going to fall since the consequential amendment wasn't voted for, but I need advice on that. I beg your pardon.
Correct. You're absolutely right. We don't need it. Ah, we're nearly there. Bear with me. Bear with me. Before I put what will be the final question during this committee stage, I need to make a brief statement about the arrangements for tabling amendments to report. This information has been provided by emails to members of the committee and to others with an interest in the progress of the bill, but I repeat it here for the convenience of members and any wider audience with an interest. The Public Bill Office will be accepting the tabling of amendments, new clauses and new schedules to the bill by email only from the moment the committee reports until 10 a.m. today, when they will be tabling by all the usual methods, so overnight by email from 10 o'clock on tomorrow to this morning, the table office will be open. This means that members may not come to the dais with tabling instructions once the bill is reported. Members are strongly encouraged to wait for the publication of the bill as amended in committee before tabling amendments to the existing clauses and schedules, so that amendments can reflect the changes made by the committee. Anything sent to the Public Bill Office overnight will be dealt with by the staff in the morning, and that bit is redundant. And while I'm strictly out of order, can I add my thanks to, first of all, the staff of the House and the officers, doorkeepers, the Hansard writers, and the clerks without whom our job as chairman and your job as committee members would frankly be impossible. And can I thank all of you for what I understand from colleagues and certainly from my personal experience has been an extremely courteous discussion of a very, very difficult bill. I congratulate you all, on whichever side of the fence you are, for the way that this has been conducted. Most grateful to you. The question is that I do report the bill as amended to the House. As many of that opinion say aye? Aye. Contrary, no? The ayes have it. Order.